Yeah. I hate when people start taking with the Marsh and wetlands.
Exactly.
Part of our flooding problem.
Testing.
It can't be turned off either.
I like that. You can turn them off.
I tried to, but he's got to do it after. Got to move.
Yeah, well, that's good.
Jenny, you're on now.
Okay. All right. Yeah. Okay.
Variance was good.
We'll have to do all the legal.
No side conversation.
Mic is good. I mean, the mic is good.
Yeah, the mic is good. Thank you.
Radio on my left,
Yeah.
radio on my right. Good.
I don't know.
Afternoon. Thank you for your patience today. We had a few technical difficulties we needed to work out prior to starting tonight. And since all these meetings are recorded, we have to make sure that our mics are live so that everything can be recorded accurately. I would like to call to order the March 7th, 2020 meeting of the Charleston County Board of Zoning and Appeals, also known as the BZA. Board members that will hear your case tonight are as follows. I'm William Ray, I'm your chairperson. To my right, we have Mr. Nelson, Ms. Asbill, Mr. Freeman, and Mr. Marchant. To my left, we have Mr. Boykin, Mr. Williams, and Ms. Switzer Smalls. Staff members present are Mr. Spencer Antos, Ms. Sally Brooks, Mr. Josh Downing, Chris DeBoot, Ms. Savannah Murray, Jennifer Stiles, and Ms. Jenny Working. Mr. Kevin Hughie is our attorney, which is to my right. Because the hearing tonight is a fact-finding meeting, and we are in compliance with the Freedom of Information Act of South Carolina Code 6-29-70. 15 days prior to the hearing, an announcement was printed in the Post and Courier. A sign was posted near or on the designated property. A notice was mailed to the applicant or the applicant's representative, to the property owners within 300 feet of the property, and to parties in interest. Persons, organizations, and news media have been given declaration of our meeting and also have been notified. The first thing we're gonna do just here for our board members, and this is new for us today. We typically do this in our chambers in the back, but we're gonna do our election to start off with, okay? So the first order of business today is gonna be the election of officers for this year. I'm going to open the nominations on the floor at this time, and the first chair will be the one I'm sitting in, the hot seat. For chairman, do we have a nomination for chair?
I would like to nominate Mr. William Ray as chair.
Okay, thank you. Okay, we have a second down here, Mr. Marchant. Do we have any other nominations? Okay, well, good. That one's close. It was unanimous, pretty much. And, yeah, we're gonna call for the vote on that one, pretty much. So all those in favor of electing me as chairperson, please raise your right hand and say aye.
Aye.
Vote for myself there too. Good. That passes. The second seat that we have is for our vice chair. Do we have any nomination for our vice chair? Well, I'll make a motion.
Go for it.
Be for Mr. Boykin, who's been sitting here to my left for quite some time. Do we have another?
A second.
Okay, Ms. Switzer Smalls. I heard it, but I was looking your way. Okay, any other nominations? But this time we'll close the nomination since we don't hear any. But let's bring it to a vote. All those in favor, please indicate by saying aye and raising your right hand. Aye. Any opposed? Good, that carries. The next seat we have is for our secretary. Do we have any nominations for our secretary? Well, go ahead.
I will nominate Ms. Working to continue as our secretary if she would so oblige us.
And I will also second that. Any other nominations for secretary? We'll hurry up and close that one. Okay, that one's closed. Let's bring it to a vote. All those in favor indicate by saying aye and raising your right hand. Aye. All right. Congratulations, both Mr. Boykin and Ms. Working, for your position here. And we thank you for all the work that you're going to do for this new calendar year. So thank you. Board members, the meeting notes for January 10th, 2020, were public hearing were mailed to you. Are there any changes? If not, can I have a motion to approve and a second? I move to approve.
Second.
All right. All those in favor, please indicate by saying aye and raising your right hand.
For there's 2 minutes,
Wait a minute.
Mr. March, can't second that.
This for the January meeting?
That's for the January meeting.
Marsh wasn't here, that's why.
Okay, ooh, thank you.
Is that for the January meeting?
That
I
is for
apologize.
January meeting.
I thought it was February. I can't do that.
So, Mr. Marchant, you can't vote on that one, as well as Mr.
I wasn't
Williams.
here. I wasn't here.
You were not here, and Mr. Freeman. So I'm gonna need another,
I'll also move.
okay, good. Thank you for catching me on that.
Need a second?
Yes. All right. So we have a motion that it has been properly moved in second. And we need to bring it to a vote. All those in favor, please indicate by saying aye and raise your right hand. Aye. For the vote, okay, good. Now for the February 7th meeting. Minutes were mailed to you. Are there any changes?
No.
You can vote this time, and you could also make a motion.
I'll make a motion to approve.
Okay, good.
Second.
And you were here. All right, let's bring it to a vote. All those in favor indicate by saying aye and raise your right hand.
Aye.
Any opposed? It carries. Good, thank you.
I thought Mr. Freeman.
Our case rulings for this and any BZA meeting are available to the public viewing and inspection during normal business hours at the Charleston County Board of Planning. The Board of Zoning Appeals is a quasi-judicial body that has final decision-making authority on appeals of zoning-relating administrative decisions. The BZA is authorized to hear and decide appeals only on zoning-related matters where it is alleged that there is an error in the order, requirements, decisions, or determinations made by the administrative official in the administration or the enforcement of any zoning-related regulations. A 2/3 quorum present is required to overturn the decision of the planning director in an appeal. Next, we have a special exception. A special exception is issued by the BZA authorizing a particular use in a specific location when the zoning district is demonstrating that it complies with all the conditions and standards specified in the Zoning and Land Development Regulation Ordinance, also known as ZELDAR. The BZA must find that a special exception must meet all 6 of the approval criteria in this ordinance in order to grant a special exception. A simple majority is needed to grant a special exception. Then next, we have a variance. A variance is a relaxation of the BZA's regulation of the ordinance, where it is such an action is not contrary to the public interest and where the conditions that on the particular to the property and are the results of the action or the situation of the applicant. A literal enforcement of the code will result in the unnecessary and undue hardship. And such variance is consistent with Section 6-29-18 of the Code of South Carolina under Title 6 and Chapter 29. The BZA must find that the variance request meets all 7 of the approval criteria of this ordinance in order to grant the variance. With this one, you have to have a 2/3 vote of the quorum present to pass the variance. Our purpose tonight is for interested parties to be heard in order to assist the board in granting the evidence and to gathering evidence pertinent to each case. If a member of the BZA finds a need for further information to clarify the case, the board has the authority to subpoena witnesses. It must be understood that the rules of your neighborhood or your subdivision are binding and that we cannot take any action that would neglect their jurisdiction over your property. In addition to your testimony, our board has been presented written information submitted by staff, by the applicant or the applicant's agent in each case. This information is now considered to be evidence and is entered into the permanent record for this body. It is assumed that it is complete, true, and accurate. In addition, we have been presented data assembled by the staff for the purpose of clarifying the location, the application's effect on surrounding property. Our board is empowered to approve with conditions, or deny a special exception or a variance request. We are also authorized to defer a case should there be a need to obtain additional information. The BZA's final decision will be mailed within 10 working days of the hearing. It will be mailed, certified mail to the applicant, and U.S. mail to neighbors and a community of interest. If an applicant's request is approved, the applicant should contact the Charleston County Zoning and Planning Department staff to discuss the next steps in the process. Variances and special exceptions granted tonight are valid for 12 months, and a 1-year extension may be granted only if construction is being commenced or has been diligently pursued. However, if an applicant's request is disapproved, and if the applicant wishes to appeal this decision of this board concerning the case, an appeal must be addressed by the circuit court. South Carolina Code 6-29-820 states that an appeal must be filed by the applicant within 30 days of the decision of this board when it is mailed to them. Failure to file an appeal within the time deprives the court of the jurisdiction to hear the matter. Because this is a quasi-judicial body, everything said in this meeting must be complete, true, and accurate. All the information provided to the BZA is considered evidence. And this board may certify contempt of circuit court if false statements are made either orally or in writing. Each person that wishes to address the board tonight will be sworn in by the BZA secretary before they provide testimony or evidence. In order to expedite this procedure, those wishing to speak will asked to stand, and Ms. Working will administer the oath. So this time, if you want to speak, please stand. And raise your right hand.
Please stand and raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. I do. I do. Thank you.
Thank you, Ms. Working. I will now call each case by case number. Staff will present facts that are pertinent to each case, limited to 5 minutes. I will then call the applicant. The applicant will stand and state his or her name and current address for the record before presenting testimony that will be pertinent to the case, limited to 5 minutes. I would then ask for those speaking either in support or in opposition to the case. And they will follow the same procedure for identifying themselves and are limited to 2 minutes. The applicant will then be given a chance to reply to any opposition, limited to 2 minutes. And the BZA will make a motion to close the case to the public. Finally, the BZA will make a motion concerning the application stating specific findings of facts and conclusions of law. Tonight, we will hear 7 cases, 7 new business cases. Ms. Working, when you get settled. First case tonight is case BZA, that's 01-22.
And Mr. Freeman, he had to recuse himself from this case.
Okay. So let me repeat, that's case BZA-01-22-00547.
Okay. The applicant, James Southard Jr. of Baylight LLC, on behalf of the property owner, Terry Southard of Baylight LLC, is requesting a variance to allow a 20-foot wide vehicular access way from a proposed bridge and a 4-foot wide walkway to a proposed dock to encroach within the required 35-foot OCRM, which is the Office of Ocean and Coastal Resource Management Critical Line Buffer at 4450 Hagen Road, and that's TMS number 09600 071 in the St. Paul's area of Charleston County. The subject property and adjacent properties to the north are located in the agricultural residential AGR zoning district. The surrounding properties to the northeast, east, south, and west are located in the town of Magnet. The subject property contains 2 areas of highland. The 2021 survey indicates Island A contains 9.83 acres of highland and Island B contains 0.12 acres of highland. The remainder of the property is surrounded by approximately 74 acres of marsh, adjacent to the Tugadoo Creek. The applicant proposes to connect Island A to the mainland with a bridge commencing on the Hagan Road easement between mainland Lot 3 and 4. So that's on this plot here. The applicant proposes to connect Island B to Island A with a dock that extends beyond Island A. Hagan Road is accessed from Tugadoo Road. Hagan Road begins as a 50-foot public right-of-way, then turns into a privately maintained 50-foot right-of-way with a 20-foot egress easement. The proposal includes construction of proposed bridge, head walls, and proposed fill material areas to the bridge located within the required 35-foot OCRM critical line buffer. So the areas we're talking about here are the areas on the highland that the bridge would attach to. So the area 35 feet on the Hagan Road side and then also on Island A. And this is a diagram of the dock that goes across, that starts on Island A and goes across to Island B. These are the zoning ordinance requirements for buffers. And the zoomed in aerial photo and zoomed out. And a couple of photos of the property. These are some of the critical areas on the property. This is on the left, the road's, I believe, public, and then it turns into a private road. And this is the end of the Hagan Road and the easement. So as far as the criteria is concerned, we stated that it may meet 1 and 3 and 6, and it may not meet 4 and 7, and that it meets 5. And we request, if you do approve this application, to approve it with conditions. Prior to zoning permit approval to begin construction, the applicant shall meet all requirements of the SCDHEC OCRM for the bridge and dock and shall provide proof of SCDHEC OCRM approval to zoning and planning staff. And 2, all construction shall be contained within the deeded easement. 3, prior to commencing construction, silt fencing shall be placed between the construction area and the marsh. The silt fencing shall be maintained for the duration of the construction. And 4, once construction has commenced, it must be carried to completion in a manner to minimize the period of disturbance to the environment. And 5, prior to commencing construction, a landscaping plan to restore the critical line buffer shall be submitted to zoning and planning staff for approval. Upon completion of construction activities, all disturbed areas must be immediately restored and reestablished according to the approved plan. And these are the plans that were submitted for this case, as well as to DHEC OCRM. Again, this is the bridge plan, the bridge, and then the dock plan. Do you have any questions?
Mr. Borkin?
Good evening, Ms. Working, how are you?
Good.
The variance request is specifically for where?
So it is for where so on the Hagan Road side, it would be from the critical line 35 feet inward.
Sure.
And then if they got the bridge approved, it would be from the 35-foot measured from that highland back on the island.
I just wanted to make sure that was going to be for both the island
Yeah.
and the mainland. of the
Because we don't
project.
have
Okay.
authority within the actual critical area. That's where OCRM comes in, but we do have the protected buffer that can't have disturbance. So we're considering this bridge to be disturbed area.
Thank you.
Mr. Marchant?
Just to follow up on that question, so the extension of the easement of the road goes to 4 properties, is that right? then-
It goes through 3 to 4.
Okay, 3 to 4.
Yeah.
So that last one on the tip is a residential lot, right? Lot
Yes,
4, I think is
4.
what it says.
Yes.
And then the bridge to the other island, I think it's called Island A, is that correct?
Right.
That island is not subdivided nor meant for development, or is it meant for just access to a dock? I'm trying to just understand the use of the island.
Proposing to use it for a single family. It's AGR zoning.
It'd be just one, okay. What's the zoning of the 4, is that also AGR?
For which one? Sorry.
4 lots?
Yeah, y'all can't see it very good because it looks very washed out. But
So that's
those lots
AGR.
are also AGR.
Okay, thank you.
Sorry for that. But in your packet, the map's a lot clearer.
Anyone else?
Question.
Williams?
So, the applicant, is this bridge and everything, is that gonna be kind of going over their property?
So they own the entire property.
Both sides of this bridge, I guess? And then what about, like, neighboring properties? Are there houses nearby there, or what?
Yes, along Hagen Road.
How far is that from their proposed bridge?
I don't know the exact distance of the residence, but, sorry, I'm going the wrong way. There we go. You can see. It's hard to tell, but there are residences along Hagen Road.
Is there a road that goes to their proposed bridge? I can't tell.
It's grass, but it's an easement, and it's named Hagen Road, the easement.
Go ahead.
Real quickly, Ms. Working, I'm looking at one of the plats submitted by the applicant dated October 8th, 2021. And on the plat itself, it describes Island B as non-buildable, 0.12 acres. So they would not be able to put a residential or dwelling unit on that island because it's simply too small. It wouldn't even have the ability for the setbacks. Okay, thanks.
Yeah, correct.
Okay, go ahead, Mr. Marchant.
To confirm what you're asking, that's the 4 lots we're talking about? I mean, you could not get I'm sorry.
I was referring, there's Island A and Island B. I think Island A was the location they intended to maybe put a
Bigger
dwelling.
one, yeah.
The
Oh,
big
yeah,
one, yes, sorry.
Yeah. I'm with you, thank you.
Anyone else?
I have one more question from Ms. Working. Do you know what is that bridge going over? Is that like marsh? Is that water or what?
It's marsh.
So it's just marshland? Okay.
I guess it just depends on the tide, how much,
20-foot bridge they're proposing?
20 foot wide.
20 foot wide and how long?
Let me get, I have that, but let me,
180.
Okay. 387.
385 feet long.
We had Ms. Murray, and who else went out with you? Did you go out on that one? Just Ms. Working? Okay. Any other questions of staff? Okay, very good. Is the applicant present tonight?
Yes, sir, Mr. Chairman.
Thank you, sir. Please come forward. Please state your name and address for the record, and please tell this board why we should approve your application, sir.
Appreciate your time tonight. James Southard, do you need my address?
Yes, please.
1925 Savannah Highway, Charleston, it's West Ashley.
Thank you, sir.
Time tonight, I appreciate all the hard work that staff did. I got the email and it was 87 pages there and I was blown away. I was like, wow, there's a lot of work going on. Y'all need to double your fee because the staff, they're really busy. So a couple things about this property. First of all, there's been some hearsay out there that it lies within the Ace Basin, okay? And you may have seen some of that. It is not in the Ace Basin, and I have a map that Ms. Working, I believe, is going to pull up. Do you have the other one that I circled where the property was? Yeah. See where she's pointing on the map up there? Okay. So there's a section 162, the red line there, that's the boundary. There's 162 there, and then there's Barrowville is right around the area where the Tougadoo is crossed by Highway 174. And my property is not in the Ace Basin. So I wanted to make that clear because there'd been some talk about that. There's a narrative out there about it being in the Ace Basin. Other thing, when I purchased this property, I researched it in depth and made sure that the access was proper to the property. I made sure that I met the bridge regulations, the guidelines for the small bridge. It's actually 15 feet wide. That's how wide they give you. The access that I have is 20 foot going down there. That was dedicated in 1977 by Early & Gethers. If you pull up the plat, Ms. Working, of the 4 lots that were mentioned, okay, back right there, you can see there's a 50-foot road there with a cul-de-sac. And there's a 20-foot access easement that predated that, was 1977. That easement in the deed specified vehicular access. Now, we have fee simple title to the marsh and to the islands. So I'm not trying to cross any state marsh or anything like that. There's 74 acres of deeded marsh. So it's private. And that 20-foot access goes down there and dead ends into that marshland. So the intention was for this to be used as residential property. Now, the previous owner couldn't afford to do a bridge. And you can't just go out there and dig like you used to back in the day. Many, many years ago, you'd have just dug and put a causeway across there, but you would impact the marsh, and so you couldn't do that. So the previous owner never put the extension over to the highland. So what I've done is I've asked OCRM for a bridge permit to do that. But part of the situation here is that I've got about a 10-acre island there that I really can't get to and use because the buffer goes all the way around it. So regardless if I get the bridge or not, I still need this 20-foot access to be able to get a bush hog over there to clean the property up and use the property. If I don't get this access through this area, it's tantamount to me having a piece of landlocked property that I can't use. The intent was always to have that easement there and to be able to use it. And the deed that is part of the file specifically says vehicular access. It says foot and other things too, but that was the intent. And so, you know, I'd be happy to answer any questions that you might have about this project.
Very good, very good. First, could we put the timer back up here?
I have it.
Is it not? Okay, is it working on the screens anymore?
It doesn't work when you move around, so that's why.
Okay. Wait, let me see if, Mr. Boykin, you have a question?
I do, a few actually. Good evening,
Good
Mr.
evening,
Southern.
sir.
Should I say Dr. Southern?
Yeah. You don't need to
thank-
call me doctor.
Thank
I'm
you
a
for
dog
coming out
doctor.
tonight. I guess I put a lot of time in this case in preparing for tonight because it's got a lot of issues. It's a lot of moving parts to it.
Yes, sir.
And I want to start off with the map or boundary question that you brought up. I think there's some confusion. There are 2 maps that are out there. One is for the Ace Basin focus area, and one's for the Ace Basin task force area. I concur with you that your property doesn't appear to be in the task force area map in looking at that one, but I do believe it may be in the focus area map. They're 2 different maps for 2 different purposes, but I think there may be some confusion when people decide what is and isn't the Ace Basin. But for tonight's purposes, I would agree with you that it is not in the task force area. All right. Secondly, in doing my research, South Carolina does not guarantee you access to your property by vehicle. That's not a property right that you have or I have or anyone else has. But you do have a right to access it. The easement that was conveyed from Mr. Bailey to Mr. Wright, you're correct. It says by foot or vehicle or otherwise, but that only applies to that easement. It has no application to the marsh and your island or islands. It just says you can use that easement, which is, the 1,000 and something feet and the other 200 and something feet that was the original 20-foot wide easement. But that doesn't have any bearing on the marsh and access to your island.
That permit's pending. The bridge permit is pending. So, yes, sir, I don't have that.
Sure. And so, getting back to my point, you can certainly access your island by foot, because y'all did that when you took the staff out there to walk out to it, and our staff members actually traversed it by foot, and you did as well, I presume.
Yes.
You also have the ability to access it by high water, by boat or whatever, and my contention is you certainly, it appears that you have every right to build a dwelling unit on that piece of property, or multiple dwelling units, depending on what the lot will hold with setbacks and so forth. And you certainly can apply and get a dock through OCRM and access that property by boat, much like Goat Island, Deweese, Botany Island, and all the other many islands that don't have a bridge to them. So I would disagree with you that there's an issue that you have a right to drive a car to your property.
I meant using the existing easement.
Sure.
Going to the marsh, which is part of the property.
Totally agree, you can
I
drive your
don't have a
car
right to drive over to the highland part of the island because I haven't gotten a permit.
But what I'm getting to is I don't think not getting the bridge would be an unreasonable restriction on your property, as was in your application that you submitted, that you still have access otherwise. And the law doesn't afford you as a right to have vehicle
I
access.
realize that I may not get the bridge. What I'm
sure.
asking
Yes,
for
sir.
tonight is what you have control over, which is the 35-foot buffer that's on the highland. We're not talking about the OCRM. I need to be able to get onto my highland because the buffer encompasses it.
Well, let me ask you this. If I looked at the photos correctly, is it not already cleared?
It was underbrushed, and I received a permit from staff to do that.
Right.
But I was told that I need to have a special spot to get onto the island, and I wasn't aware that I needed that, and so that's why I'm here tonight.
All right, so there's a marked distinction. So you had an easement, it's cleared, you cleared brush, you got a permit for that. But the ordinance that we're dealing with also deals with soil disturbance. And you're gonna have to do a lot of soil disturbance to build, an entrance to this bridge. And so that's what we're really here about tonight. That's different than clearing the brush, and so I want to make that point. And then the other thing I wanted to ask you about, the fee simple deed to the marsh. Many folks in the Low Country have a plat and a deed that says they own the marsh, but they don't own it. The state of South Carolina owns it. The reason I know is our family's in the same position. For you to have title and ownership of that marsh, you now have to file suit against the state of South Carolina with the Attorney General's office and successfully win that suit in circuit court. Up until then, you don't own anything. It's just drawn out on a plat and it's pretty words on a deed. But unless you've got a King's grant, a proprietary grant, or a South Carolina land warrant, you don't own it. So I just want to make that clear tonight. So you
Just have fee title to it, that's all I
But
can
doesn't
say.
give you the ownership of the marsh. It's like feel-good child custody when you got joint custody. It's the same thing. It's not yours until you go through those legal proceedings. And I know for a fact the AG's office has been instructed to fight every application of private ownership of marsh. So it's not a simple, easy thing. So not to debate that, but
Okay.
these are just more issues I want to bring up with you. So there are some other things going on. Speaking of the bridge, one of the things we have to consider, there are three of the criteria that in my research and reading the staff's report and the letters and so forth and other documentation, I don't think you're going to meet tonight, at least in my opinion. And that's criteria 3, 4, and 7. The first one is because of the conditions, you'd be effectively prohibit or unleash restrict utilization of property. As I've said it before, you have other means of access to it. And you certainly can still build a house upon it, and you can certainly get a dock. So
I'm asking for a corridor for a dock too.
sure, and that would be through
there's
OCRM,
4-foot
right? Sure.
access
but,
there.
But I don't know that you meet that criteria. And the next one is number 4. The authorization of variance would not be of substantial detriment to adjacent property, to the public good, and the character of zoning of district would not be harmed in granting the variance. In looking at your project, and I've looked all over your engineer drawings and stuff, We're talking about a 15-foot wide elevated bridge, I presume side rail so you don't drive off of it. And it's going to take up about 6,000 square feet of marsh to go to one island for potentially, I guess, one residence or maybe get a couple of dwelling units out there. The view shed of all your adjacent property owners is going to be impacted substantially by something of that size and breadth being constructed over the marsh to get there. I don't see how it couldn't be, especially with the rails and everything that are going to be involved. It's going to be, several feet above high water and king tides and all the rest of it. The other issue is that bridge is going to be built, I presume, with county standards that you're going to be able to drive a fire truck, an EMS thing, a septic tank,
Understand.
truck.
Yes, sir.
And so again, this is not a 4-foot wide, pier to go to a pier head. This is substantial, pylons and all the rest of it. And it's going to require significant soil disturbance on two critical line areas, the one on the island and the one on the mainland. The issue of the view shed, potential habitat loss of all that marsh. The other thing is, with high water, how many folks are out there, fishing and crabbing and cast netting for shrimp and so forth in those flats that may be obstructed by the bridge. Additionally, I agree with you. I don't think it's in the Ace Basin Task Force area, but it certainly is a rock's throw, as it were, very nearby. I'm moved by the letters of DNR, the U.S. Fish and Wildlife Service, and some of the other organizations of their concerns about potential wildlife habitat loss, recreational loss for the folks that live down there, the view shed, and obviously that it was mentioned that it may be black rail habitat. I realize we can play a game that there's a bird or a frog or something out there everywhere, but when you have government entities that weigh in, I take notice of that. I don't take it lightly. And then, so those are some of the reasons I don't think it's going to meet criteria 4. Finally, criteria 7, granting of the variance does not substantially conflict with the comprehensive plan. In this case, and staff has put this in here, the ordinance says that that protect and enhance the environmental quality of natural resources and continue to require restricted development standards along the OCRM critical line to protect water quality, wildlife habitat, and scenic vistas. Again, it is a large project. This is not like putting a pipe in and crossing over a narrow area. This is, and it's almost 400 feet. That's a football and a third long and 15 feet wide, and then, of course, the elevation. I think that's a bit much. I'll hear from you on what you have to say about that.
The bridge situation is pending, and I understand your concerns.
Yes,
What I'm asking for is an access point to get equipment and other things onto this island. 4 foot wide is not enough room to get what I need to get on there. Like recently, I went out and underbrushed it and got a permit for that. But in essence, when I came across that marsh with mats, I use BMP's, best management practice, came across that marsh, I wouldn't be able to get my equipment on that island without having a place to go across. Regardless if I get the bridge permit, I understand your concern there. That's a whole nother situation that's going on right now in tandem. But what I'm asking for is a spot that I can use, even if I don't get this bridge permit, which I might not, to be able to, this 20-foot area will also serve as a purpose to get a tractor over there, when a septic tank needs to be dug for this dwelling. Even if I don't get the bridge, there still needs to be equipment that can get onto this property without violating the 35-foot rule. And so that's what I'm asking for. I'm not asking for y'all to approve my bridge or to weigh in on whether it's right, wrong, or indifferent. I'm asking for a spot that I can use there to get onto this property. And that's more so than just a 4 foot, this is almost 10 acres of land, more so than just a 4 foot wide bridge walkway. Dock walkway. And we recently had the hearing, the public hearing about the bridge. And the dock situation was put there at the recommendation of my engineer, and not me. I didn't really care where it went. He said, well, if you put it there, it's a half mile either side of the nearest neighbor. It's in the middle. It'll be hidden and all this stuff. I don't have any intention of going through that little island right there. That's non-buildable island. I'm planning on putting a conservation easement on that little island. I would rather use a closer spot to the creek where it's not going to be as long of a dock and such. So that's something that I realized when I heard the complaints recently, that I'm not opposed to that. So that 4-foot little section there could be somewhere else. It doesn't have to go over there to that Island B.
Let me ask you this. What would preclude you from loading equipment onto a barge at Parrishville Boat Landing or Metal Trades or any other location like that and barging it down and floating it right on up to the island itself? And
You'll have to get onto the island.
But that's what I'm saying. Can you not barge?
But you can't get onto the island and not cross the 35-foot critical line buffer
But you're not crossing any critical line buffer.
to get onto the property. Miss Jenny, can you add to what I'm trying to say about the?
Yeah, I mean, the entire island's surrounded by a critical area. If I get to the right map.
That's probably pretty good right there.
Yeah.
'cause
Was it
shows you
always
the
surrounded
critical
by a
line.
critical area when you purchased the property?
It's an island. A whole boundary is critical line.
Was it that way when you purchased the
Yes,
property
ma'am.
is
It
what
was,
I'm
it was
asking?
like that, and there was an easement that went down to the marsh for me to go over to the island across the marsh.
And who owns the easement on the property?
The easement is owned, on the Highland side, the
Yes.
easement is owned by the Gathers family. And I believe it was their mother or the grandmother is the one that dedicated this easement on this property to Mr. and Mrs. Wright. That's who I bought the property from. Yeah.
Quick question.
Yes, sir.
It's a quick question. I guess to Ms. Smalls' point, this property was already like it is right now, correct? It already had these buffers there when you went and bought it.
Well,
It had these critical lines already there. You said you did your homework?
yes, sir. When the easement was dedicated in 1977, and rules change. Rules change. Tomorrow it might be 50-foot buffer or more. So the rules are constantly changing. The intent was to get over to the property, to the island, the highland, and so when you go and you buy a piece of property on the water, you have to get the OCRM line marked. That's part of the rule in order to get the plat approved. And so that's what I did. But it wasn't until I was working with staff that I realized that there was some provision that I would need to go through in order to be able to get equipment over there. I thought I needed to apply for a bridge permit and that was it. I didn't realize that I was going to need to come through this commission as well. So I did a lot of homework, but you do your best, but you never necessarily know everything.
Hold off on this, gentlemen. We got any questions on this side?
Yeah, I do.
Mr. Marsh?
Dr. Southard, like Mr. Boykin, I'm hung up on criteria 4 and 7. Criteria 4 says, the authorization of a variance will not be of substantial detriment to adjacent property or to the public good, and the character of the zoning district will not be harmed by granting the variance. And number 7 says, granting of the variance does not substantially conflict with the comprehensive plan or purposes of the ordinance. And it goes on to talk about, as Mr. Boykin said, some of the issues related to natural habitat, public good, view sheds. I'm hung up on those 2 criteria. I think it's very difficult to argue in favor of both of those. I'm also concerned about granting the variance and what would come after. If you never build, why would we do this if you didn't want a bridge? Why would we do this if you didn't want to develop the property and put septic tanks in? And so our responsibility as catalyst for future things that may be a detriment to the natural resources, may be a detriment to the neighbors or the adjacent property. I have concern over that. And so I'm asking you to help me understand how those two criteria can be met and that I can sleep at night thinking that I would agree with you. And secondly, the future potential development and how that might not continue to detriment the property, the natural resources, and others. I mean, we're all familiar with what's happening at James Island Creek and Ellis Creek and the septic tanks. It's ruined that creek. How does putting 2 septic tanks or 4 or 6? So anyway, I can't approve this because of 4 and 7 unless you can convince me otherwise. And so I'll just leave it to you to tell me.
What I was trying to make clear is that whether I get the bridge or not, I still need a crossing point on the island itself to move equipment on and such when I need to do things on the island. I mean, unless I'm misunderstanding what I'm trying to get, that's what I'm asking for. I'm not asking for y'all to approve the bridge or anything like that. I had to put that to show the extension of the road. But what I'm asking for is, let's say I don't get the bridge. I still need to be able to move equipment onto my property and utilize it with things other than just what I can carry over there on foot.
Yeah. And I guess where I'm going with this is decisions have consequences, and your intentions for use help me understand how a decision I make will have consequences down the line. And what I'm trying to understand is, what is your intention for the use of the property down the line?
It's a residential, one residential.
Exactly,
site.
which would require a bridge and
Well,
septic
you don't
tanks
have
and
to
all.
have a bridge. I mean, you can go like the Goat Island thing is like this
Agreed,
gentleman was saying,
but you've applied for a permit, so the intention is there.
I know, but what I'm asking this body for is a spot to get onto this property that's 20 feet wide. I'm not
Sure.
trying to do anything else. That's all I'm asking you for, is a 20-foot wide place where I can move my equipment onto the island or clear it or whatever I need to do down the line. I've got to have a way to get on my property with equipment.
Yeah, hold on. Mr. Nelson, you had a question or comment?
Well, and I think several times you've tried to vocalize this, but what you're trying to tell this board and what I'm hearing is that this bridge really is not part of the request to the BZA at this time.
No, sir.
So,
The bridge-
for example, is the area along Tougadoo Creek that's closest to your mainland. If you wanted to barge equipment onto the property, you'd probably come in at that closest location.
Yes.
But you would need a variance at that location for a cleared area to then move the equipment onto the property.
Yes, sir. That's all I'm asking for is for you to approve a spot where, let's say I don't get the bridge. It can be anywhere on the island you guys want or think is less impactful. I still just need a place to get my equipment on there.
And-
You know, I know the bridge thing is pending, and I know there's folks that are thinking I'm in the Ace Basin and all this stuff, which I'm not. I've got to have a backup situation. I can't be like just the rug pulled out from under me and say I can't use my property now. I mean, I'm just asking for a place.
And
Get
your
over to
your
my
testimony is that your intent is not to develop the property, but just to put one house out there.
That's all I've shown. Yes, sir. I mean, if I was to sell the property to you and you decide you want to do something different, then that's your prerogative. I mean, what I'm wanting to do is one house, one dock. That's what I've shown with OCRM. I mean, this is AGR property. It's 1 acre lots. You know?
Okay, Mr. Boykin?
I might have a resolution here, Mr. Sutter. I'm not inclined to vote for what you've applied for as far as the two variances for the critical line buffer. But if we were to grant you, or the board would agree to grant you your application for one critical line buffer variance on the Tougadoo Creek side of your property and condition it that its sole and only use would be for the construction of a residence and during the time that is needed to construct that residence, but not for a bridge.
I mean, My bridge permit is still pending. I mean,
That's not what I'm asking.
I
I'm
know,
asking you,
couldn't
would that
agree.
be acceptable to you?
I couldn't agree to that.
You made my point, thank you.
Yeah, I mean, I've got a bridge permit pending. I've done all this
Understood.
engineering.
Yes,
I'm still letting that run its process.
I understand you
I
loud
mean,
and clear.
okay.
All right, hold on.
Mr. Boykin, so
So do we have any other board members that have any questions about this application to this applicant?
I guess I just want Mr. Sutherland to address some of the opposition related to the marsh that's out there and maybe potential further degradation to Tugadoo Creek and some of the natural habitat out there. Have you done any impact studies, or how can you address that for the board?
The buffer is going to be left in place around the entire island. That's how it will be protected, is that the buffer that we're talking about right now is going to be in place. Many of the adjacent property owners have their yards, their manicured yard goes all the way to the edge of the creek. This is wooded. This is a whole wooded island, and there's the buffer is there to do its job. That's what it's there for. I mean, I'm not going to be putting a manicured lawn all the way down to the edge of the marsh like many of the adjacent landowners have. I'm going to leave that wooded. I have to. That's part of the process. And so that's how I would address it, is I would say that the only place that I'm going to go through is the one that you approve for me. And that's 20 foot wide. That's what I'm asking for. If I don't get the bridge, which I'm trying to get, okay, and I don't get it, then that's what I have to live with. I understand that. I understand that choice. But what I'm asking you here for tonight is allow me to get onto my property with enough of something that I can get equipment and such on there. I mean, I don't think that's asking too much. This property was for sale for 2 years, more than 2 years. And any of those neighbors that are in opposition could have purchased this property. And if they didn't like this didn't want something to happen on this property, you know? So.
Thank you.
Thank you.
Ms. Asbell, you're the only one that didn't get an opportunity. Do you have a question or comment? Ms. Asbell, did I? Okay.
Thank you for your time, even though I know we, at times.
Want to make sure that you heard and give
Okay.
every board member an opportunity to ask you any questions that they may have.
All right.
Thank you, sir, for your testimony today. Yes, sir. Do we have anyone else that'd like to speak in favor of this application? Do we have anyone else that'd like to speak in favor for this application? Okay. Do we have anyone to speak in opposition on this application? Yes, sir, I saw your hand first. Ty, glasses, sir. Please come forward. State your name and address for the record, sir.
My name's Tom Hutto. I'm,
Pick it up, Mr. Huddle. There you go. You're a little tall there.
don't start my time yet. Hey, my name's Tom Hutto, 4533 Hagen Road. Thank you for letting me speak. First, this project is within the Ace Basin Task Force boundary area, which is OCRM's criteria. The boundary for the task force boundary area is along Highway 165 through Megan. Mr. Charles Lane, president of the Ace Basin Task Force, has submitted documentation that this property is within the Ace Basin Task Force boundary area, and who would know better than him? He is the president of the Ace Basin Task Force. In addition to state law 483970, which prohibits local governmental bodies from issuing variances contrary to the Coastal Tidelands and Wetlands Act, this variance should be denied since this project fails to meet the 7 required criteria. 2 criteria that are not met are: 1, criteria 3, application of the ordinance would not unreasonably prohibit or unreasonably restrict utilization of the property, as this property, like many islands in Charleston County, can be accessed by boat. Criteria 6, the need for the variance is the result of the applicant's own actions. Like any experienced buyer, the owner should have performed adequate due diligence to ascertain the property's limitations, meaning that it is only boat accessible for his planned use. My understanding is he previously obtained a bridge permit for a marsh island, so was familiar with these regulations. Furthermore, this property was sold at a price much, much lower than nearby similar mainland property. The former owners knew of DHEC's restrictive regulations and the property's limitations and appear to price the parcel accordingly. So, this variance fails on many levels and should be denied right here and right now, not delayed. The applicant should be required to revegetate the buffer, which he cleared without a permit. He got a permit after the fact, period. It would be unfair to allow this issue to drag out when it is clearly not approvable and opposed by the neighbors and the entire community. Thank you so much.
One moment. Does anyone have a question of this gentleman? Mr. Nelson?
Mr. Hutto, it's good to see you again.
Mr. Nelson?
One question for you. So the applicant has testified to us that he has to have access to get equipment onto the property regardless of whether or not there's a bridge there. Is there a means or a mechanism by which the neighboring property owners, adjacent property owners, would allow for some type of access or encroachment upon that buffer so that he can get equipment to the island?
I don't know what the neighbors would allow. I do know that what we've seen tonight is not reflected by where you would bring a barge in. I think Mr. Boykin made that point. So what's before you all tonight is not a realistic request. One side, I want a bridge. Other side, well, maybe I'll bring a barge in, but I just need access somewhere. Well, somewhere needs to be on a drawing. It has to be something you all can look at and approve. So that would be my thought. But I can't speak. I'll let my neighbors speak for themselves. We live on Hagen Road, and it's a private road, and there's no deeded access to this property beyond that little bit that you showed on that drawing. Thank you very much.
Thank
Any
you.
other questions?
Thank you.
Just a quick one. Good evening, Mr. Hutto. I think the point we just brought up, and Mr. Eugene spoke with me, this board does not have the authority to change the application to put the disturbance of the critical line buffer in another place. That would have to be a future application, specifically with the site plan and everything, just like you said. What I wanted to follow up with you, you live nearby?
I'm 3 or 4 houses down on Hagen Road.
Do you utilize the marsh, the creeks, and the Tugadoo?
Many of us have kayaks, canoes, motorboats. So yeah, the marsh is great for kayaking. You can go around most of the island pretty much at high tides. So certainly it's very, in kayaks, it's pleasant to go in the quieter water at high tide. So yes, we all do use it, or many of us use it, I should say.
Are there any other like structures, or any other bridges in that area that you're aware of to a private island?
There are no, not that I know. This would be a precedent within this area. And this is, as you pointed out, I believe it was you, this was a huge structure. And some of our neighbors who are here, their properties, which have been in their families since the 1800s, will be totally devalued by having this big structure right out in front of them. They've held on to this property for a very long time. This is going to really change the character of the neighborhood, not to mention it's a private road.
That was going to be my next question, because you do live very close by in the area and are familiar with it. I was going to ask your opinion whether or not you thought that this structure would stand out or change the character of that area.
Hugely. There's nothing like it on Tugadoo Creek that I can think of.
Okay.
We're, of course, up and down the creek all the time, maybe on the lower Tugadoo. This end of Tugadoo, quiet, largely undeveloped. It meets the definition of, well, the Ace Basin Task Force boundary area. And perhaps it's confusing, but Mr. Lane and my research of DHEC regulations this is within their regulatory area that does prohibit bridges to Marsh Islands, except in very narrow exceptions, which a private residence will not, qualify for public need or public benefit, which are requirements.
Okay. Thank you.
Does anyone else have a question for Mr. Hutto? Thank you, sir, for your testimony today.
Thank you for your time this evening. We appreciate it.
Do we have anyone else like to speak in opposition? Yes, ma'am. Lady first with the red shirt on. Thank you. Please come forward. State your name and address for the record, please, ma'am.
Yes, excuse me. My name is Deborah Gathers. My address is 5501 LA Glen Court, North Charleston. I am the property owner of TMS 550-162 Lot 2. I am notifying you and your committee that I strongly oppose the granting of the request to allow the construction of a vehicular access way from a proposed bridge and a walkway to a proposed dock to encroach within the required 35 feet OCRM critical line buffer. My reasons are as follows. The construction of a bridge and a dock will be a detrimental encroachment to the wildlife that inhabits the area and will severely impact their food source and habitat. The construction of a bridge and dock will severely alter the natural habitat, the wetlands, and the aesthetics of my property, which is Lot 2, and the surrounding property, so I have ecological concerns as well. The construction of a bridge and dock will increase travel in the area, thus resulting in a disruption and loss of the serenity of the Hagen Road community. Also, the increased travel will require additional road maintenance. Who will be responsible for that road maintenance? The Hagen Road residents are currently maintaining the road at their expense and time. The negative environmental impact will be severe and disruptive. The previous owner assigned a statement on document Hagen, Rhode Island Access Easement Exhibit that she dedicated the 50 feet road right-of-way to the sole use of the property owners of lots 1, 2, 3, and 4. It was not, fifthly, I was not contacted by anyone to discuss the possibility of encroachment to my property or the surrounding properties. And I have not consented to any utilization of my property. Therefore, I am saying that I definitely disagree with the variance, and I request a study to be conducted to determine the impact of this project to the surrounding areas. My sister, who also owns property out there, was unable to attend. She has a sick husband that she's taking care of, and she wanted me to read her letter. Is that admissible?
Ms. Gathers, unfortunately, you're out of time unless we have a board member that would like to give you more time. Well, first, before we do that, let me see if a board member would like to ask a question. Mr. Nelson, I see your hand reaching for the thing.
Ms. Gathers, I'd love to hear your sister's letter.
Oh, thank you.
Thank you, Mr. Nelson. Go right ahead.
So she writes, my name is Onetha Washington, and I reside in St. Stephen, South Carolina. I am writing to state my opposition to the granting of the variance request. I am the owner of parcel 09600000161, depicted in the plans of the proposed bridge. It appears that my property will be very negatively impacted by the construction of the bridge by using the edge of my property as fill and buffer in the initial stage of construction. I am also concerned about heavy vehicles, equipment, and materials going back and forth over my property. The builder claims to have easement access, but I don't know if that is correct according to the documents I have from my deceased heirs. I believe it would be beneficial to all if an impact study could be done by the county or the builder to gain information regarding the effects that the project will have on the delicate environment in the area as well as the quality of life in our community. I am concerned about the predatory seizure of parts of my property by this builder. Some of my trees were already cut down without my knowledge. Hopefully, my concerns and the concerns of my neighbors will be considered in making your decision. Thank you for allowing me to read.
Thank you, Ms. Gathers.
Ms. Gathers, can you confirm which lot your sister owns?
Do we have anyone else that'd like to have a question?
Ms. Gathers, thank you for coming out tonight.
Hearing.
Real quick, I was just going to ask you, you're on Lot 2?
Lot 2, correct.
Looking at the plat I have, it looks like you're only about 600 feet from where this proposed bridge or this disturbance area of the critical line buffer would be. Would that be in your view from your property looking out at the marsh?
Good.
Thank you.
Thank you.
Ms. Gathers, please submit your letters if you wanted to be part of the record.
Do we have anyone else that have a question for Ms. Gathers? Thank you, Ms. Gathers, for your time tonight. Do we have anyone else that'd like to speak in opposition to this application? Yes, sir. Gentleman in the green shirt. Please state your name and address for the record, please, sir.
Yes, good afternoon, Board. My name is Ricky Green. I reside at 7579 Oakville Road. My family owns the property, got two TMS. My uncle and my father own TMS 09600000065. My uncle owns 09600000072. And each property comes to the center of the existing way right now. It's not a 50-foot right-of-way. I've heard that there's a 50-foot right-of-way all the way through. One part is maintained and the other part is not, but that two particular properties, there's no right-of-way, as far as my knowing. I've been there all of my life. My family farms, and right now, we don't want to extend the right-of-way beyond what we have now, which is they call it a community road. Some of the older people call it a wagon road. Because of being there, they cannot close the road. It's an access to get back there, but I measured it range anywhere from 10 to 13 feet travel way right now. I don't know where they come in saying there's a maintained 50-foot right-of-way in there. Those two particular properties butts in the center of that road. And the property on that particular area is owned half of the road to my father, half of the road to my uncles. Their family, both have deceased now. And like I said, we've been farming all of our life. We are currently farming the property now. And we don't want to disturb the area than what we have now in the decrease, because right now it's very hard to find land to farm. And I want to continue, I'd like to continue that within my family and also for the generation behind us. Thank you.
Moment, Mr. Green. You said your TMS number, what was the last three digits?
Last three, 095. No, I'm sorry, 065 is my mother's. 072 is my uncle's.
Okay. Mr. Williams, you have a question for Mr. Green?
Is there a way that the staff could open up this, the map with the different properties, so he could show us which property he's?
I don't see those numbers on the map.
I don't either.
I mean, they're probably, I mean, they're there, but they're just, the numbers aren't there. So.
Oh, sorry, okay.
Does anyone else have a question for Mr. Green? Thank you so very much tonight for your testimony, sir. Do we have anyone else that'd like to speak in opposition? Yes, ma'am.
Some slides.
Please come forward and state your name and address for the record.
Hi, I'm Frances Newland of 4555 Hagen Road.
Newland?
Newland.
Newland.
I'm here on behalf of my parents, Thomas and Lisa Newland, who are unable to attend tonight. Sorry. We have lived at the 4555 Hagen Road address since 2010. And I would like to speak directly to criteria number 4. We moved to Tougadoo because of its beautiful environment, boat, fish, kayak, and swim in the creek when the seasons allow. The Marsh Islands at issue are part of the ecosystem that we use and enjoy. There's a 6 to 7 foot tide change in the creek, and at higher tides, the marsh behind the bigger marsh area is flooded, which is where we like to go kayak and fish. Also, the deep channel in the Tougadoo, where the proposed dock would be located, is the only deep channel at that area of the creek. So at low tides, the dock would impede any boats coming in or out around that area for anyone who lives up or down that part of the creek. The proposed development will also impact how neighbors and us will be able to use the marsh and the environment. Also, granting the variance brings up the issue of the use of Hagen Road. My father owns a large portion of the privately owned and updated, maintained part of Hagen Road. We have concerns that granting a variance will encourage trespass, misuse, and abuse and damage of the road and surrounding trees, because it is a very small dirt road, hard to get stuff up and down. The applicant has never asked my father for permission to use any part of the road previously that he has used to bring equipment down. So my parents, my family, and I, we oppose this variance. Thank you.
Okay. Do we have anyone that has a question for this young?
Quick question.
Mr. Williams?
Yes, how you doing today? How do you go from, what is the next main road that you get to from Hagan Road? Just trying to get an idea where
Is
this is at.
Tiggity Road.
And then, okay, this is in Megget, South Carolina?
Yes, sir.
And then, like, is that by like Highway 17 or what?
Yes.
Okay. So you will eventually get to Highway 17 from this road?
Yes.
Okay. I'm just trying to get an idea where this is located at, because I'm sure you're more familiar than I am, but appreciate it.
Does anyone else have a question?
Just a real quick.
Yes, sir.
Mr. Chair. Ms. Newland, thank you for coming out and speaking tonight. Again, I'll follow up as I have asked others. You live there. Do you frequent the marsh and estuary in the area where this project is being sought?
We go out in the flats boat or the kayaks whenever it's the right season. I was actually out on the dock all this weekend. It was nice and peaceful with our animals, but we don't do a lot more other than that impedes the marshland, other than just at high tide going into it.
Okay. Is it fair to say that it's a substantial amount of wildlife and fish and marine mammals
I've
and all the rest of that
had
going on?
friends come over and wake up and they're like, there's so many birds, there's so much noises.
Okay.
We watch the dolphins.
Looking across the marsh out there where this island is, the larger island, and where the bridge is proposed and the areas of disturbance are sought, is that for lack of expression, is that a scenic vista to you?
Yes, it is. It's right from where we look out across in the docks.
And do you think a bridge that's nearly 400 feet long and 15 feet wide with side rails, would that obscure or disturb that scenic vista?
Definitely change the scenic.
Okay, thank you. No further questions.
Anyone else? Thank you so very much for your time today and your testimony. Do we have anyone else that would like to? Yes, ma'am. Good evening. Please state your name and address.
My name is Mary Atkins. My address is 4573 Hagan Road. First, I'd like to provide a more accurate description of the road and the easement. Some of this has already been discussed, but here it goes. From Tougadoo Road to the street sign, Hagan Road is public. Eastward of the sign, the road is private and maintained by neighbors. Private Hagan Road ends where parcel 163 begins. That's Mr. Gether's property. The easement is not contained within Hagan Road. The grass is not Hagan Road. The ingress-egress easement is only over parcels 161, 162, and 163. The easement is for ingress-egress only, and parcel 161 owner, Onetha Washington, objects to any construction or structures on her property. Allowing the variance will cause damage to private property by construction vehicles and will increase neighborhood costs, concerns about trespass, and security. I'd like to assert that conditions 1, 2, and 3 are not satisfied and request the variance request be denied. 1, the conditions are not exceptional or extraordinary. All marsh islands within the Ace Basin Task Force boundary area, which this island lies within, are to be treated the same when it comes to building bridges and disturbing buffer zones. 2, other marsh islands within the Ace Basin boundary area are treated the same, and the 35-foot buffer aligns with the purpose of the regulations regarding bridges to marsh islands within the boundary area. Upholding the 35-foot buffer does not unreasonably restrict the utilization of the marsh island. The buffer is consistent with the intended utilization. The island's utilization is informed by its location within the Ace Basin Task Force boundary area, its importance to our ecosystem, and project standards set forth in Regulation 30-12N. The $225,000 paid for more than 70 acres is consistent with knowing that the marsh island's intended utilization would need to be consistent with ecosystem preservation and a 35-foot buffer. Marsh islands are protected because they are fragile and critical part of the coastal ecosystem. Thank you for your time.
Thank you so very much for your testimony. Do we have anyone that has a question or comment? Thank you so very much for your testimony tonight. Do we have anyone else? Yes, ma'am. Good evening.
Good evening.
Please state your name and address for the record.
My name is Diana Reed. I live at 4573 Hagen Road, Meggett, on the Tougadoo Creek, around the bend from the Marsh Islands, recently purchased by the applicant. The islands sit in the Ace Basin Task Force boundary area. The 35-foot buffer protects Marsh Islands. These rules complement the regulations which prohibit bridges to Marsh Islands in the Ace Basin Task Force boundary area, except for overriding public purposes. There is none here, and the applicant has never mentioned these regulations in his proposal to DHEC to build a bridge through the marsh or his request to this board. I would like to address Criterion 4. Will the variance be a substantial detriment to the adjacent properties or the public? Yes. Will the character of the zoning district be harmed? Yes. As stated previously, we have 6 to 7 foot tide changes on the Tougadoo Creek and marshes. At high tide, the marshes are completely flooded. We kayak and fish here regularly in the very marsh between the highland and the larger Marsh Island. The applicant's proposal to build a bridge through the marsh, to build another one over the smaller island, both breach the 35-foot buffer and will be a substantial detriment to the adjacent properties and the public. In addition, the second bridge over the smaller island connects to a proposed large dock that is proposed to be located in the only deep channel of the creek at low tide and will necessarily obstruct navigation. If the variances are granted, they will completely change the nature of the creek, the marsh, and the Marsh Islands. It will be a detriment to the adjacent properties, which will look out on this access, and to the public good, to how we, the people who have lived here for many, many years that you have heard from, and others use and enjoy this beautiful environment. The entire reason we live on the Tougadoo Creek and why people come there to enjoy it. Thank you.
Thank you so very much for your testimony. Does anyone have a question? Yes,
Boykin.
Mr. Boykin.
Good evening, Ms. Reed. You kayak out there and this, and so when there's full tide or a king tide, are you able to currently navigate or propel a kayak around that island?
Absolutely. We could go up through the marsh between the highland and the larger Marsh Island. We can go all the way along the inside marsh along the Tougadoo Creek.
Would it be fair to say if there was a bridge constructed, just to get over the mean high water level, whatever the clearance, it would obstruct your ability to navigate through there?
I do not think the bridge makes any provision for the allowability of people to pass the way they are now.
That's all I've got for you. Thank you.
Anyone else? Thank you so very much. Finally, do we have anyone else that'd like to speak in opposition? Yes, sir. Please come forward. I need to get some new information, folks, okay? Thank you, sir.
Good evening, Mr. Chairperson, staff members. Try to keep this short. I know you have other items to consider. This application states it is for access way to and from a proposed business.
Your name and address, sir.
Your name and address.
I apologize. Evan Williams of Bybee and Tibbles here on behalf of some of the property owners who spoke in opposition. Applications for an access way to and from a proposed bridge. Look at the application, staff comments that are submitted, they all state that. There's no evidence, as Mr. Boykin said, that of ownership of the marsh area or permission to use the marsh area. Baylight does not own the lots adjacent to the marsh on the highland side. So those 4 lots shown on the plat with the easement, they don't own those lots. They do have a 20-foot easement over those lots. It is for ingress and egress only. The easement gives them no right for construction or development of any area of those lots. They have no right to construct a base of a bridge on those mainland lots. The photo on page 9 of your materials shows that there is a no trespassing sign at Hagen Road stating it is a private road. The applicant has no right to use that private Hagen Road leading northwest from the easement area. It's on the, I think, 1991 and 2008 plats show the easement area, then the private Hagen Road heads northwest. The easement, like I said, the easement use does not allow for development or construction. In the materials, there was a letter from the mayor of the town of Megget dated December 29th to OCRM listing concerns with the bridge and potential development, structural design of the bridge, and concerns with access to and performance of public services. In closing, there's really no point in considering this application. There's no right to use the private Hagen Road. There's no ownership of the marshland. And there's no right to construct the base of the bridge on the mainland side lots. Thank you.
Thank you, sir. Do we have any questions for Mr. Marchant?
Mr. Tibbins, I'm sorry, I didn't hear.
Sorry, Evan Williams.
Williams, thank you. Are you an attorney?
Yes, sir, with Bybee and Tibbles.
Perfect. So maybe you can help me clarify the conflicting testimony between is or is not this property in the Ace Basin Task Force boundary area, because I feel like we're in conflict in some way, depending on the ruling on that. So can you help me with that and maybe my fellow board members?
I cannot give an opinion on that. I don't go into environmental restrictions. That's an opinion that has to come from DEAC or OCRM, as I understand it. I believe that is going to be part of their decision upcoming or will be included in the decision. I think there's some materials in the agenda item that speak to the protected Ace Basin area. And I think Mr. Boykin has a good understanding of the difference between the task force area and another area, but I cannot speak definitively to whether the property is in that area.
Anyone else? You had a follow-up?
I don't, just thank you, but perhaps we could get clarification from Mr. Hugie at some point tonight, because I think that is kind of a crucial item for us to determine whether or not, how we move forward.
Anyone else?
Just real quick, super quick. Mr. Williams, good to hear from you tonight. You've looked over the 1974 deed, which mentions the ingress egress. Doesn't it pretty much effectively give Mr. Southard access to where the marsh begins?
Yes, sir.
So he has that now. He doesn't need to construct or build anything. It's already cleared. He can walk right out into that marsh without doing a single thing else. Would that be fair to say?
Yes, sir.
Thank you. That's all I have.
Anyone else? New discovery. Well, thank you so very much for your time, sir.
All right. Have a good night.
Now, if we have anyone else with new discovery, we'll allow it. Anyone else? In opposition? Okay, sir. You have the right of rebuttal.
Yes, sir.
And if you would, please come at this time. Also, again, just please, for the record, please state your name and address, sir.
James Southern, 1925 Savannah Highway, Charleston, South Carolina. Mr. Chair, I would ask that we table this application at this time because there's a material issue of fact before you tonight regarding the Ace Basin Task Force area or whatever you want to call it. I hired a professional environmentalist to handle my permitting process, and he tells me that I am not in the Ace Basin, anything. And I questioned him in depth about that before I purchased this property. And I keep hearing this coming up, but I've never seen any maps or any proof given to this board that shows that my property is in that area. And I think it's a like this gentleman down here on the end said, Marchant, it's important to know. I mean, what are we dealing with? Are we dealing with apples? Are we dealing with oranges? I want to know myself, because it keeps being brought up as rhetoric, and I'm like, I'm not aware of it. I don't see a map. I demonstrated a map tonight. I showed a map to the board that shows it's not in there. It's not in the boundary. But I keep hearing that it is. The other thing about the road, that's not why we're here tonight. I'm asking for an area across on the island part of the property. I'm hearing all this stuff about the road coming in. That's a prescriptive easement. It's been used continuously for over 20 years. There's nothing to really talk about there. I'm not asking for anything to change. I'm certainly not going to mess with this
way,
gentleman's
please, sir.
farmland.
Please speak to the board,
I'm
sir.
not going to disturb his farmland. I'm not asking to widen the road. I'm just using the road like all the other property owners. I'm not doing anything. I'm not trying to get in anybody's business or hurt them or harm them or any of that. But I would respectfully ask that we table this tonight so that we can get some information and some facts before you decide, because it's going to impact me seriously.
Absolutely.
And I need to know that.
So thank you. I want to make sure that I'm perfectly clear. You asking for a deferral? Okay. So,
I would recommend, sir, if you should bring any experts that you want. You should bring any experts
Yes, sir.
to the next time.
I will. I did not know that this was going to get into this debate, but there's a material issue of fact here, and I need to know, and the board needs to know in order to make a proper decision here tonight.
okay.
He has the right to.
Yeah.
He has the right to request. He has the right to ask that his case is deferred.
Correct. So you did ask for that. He did request it. So the next thing we have to do, we're going to bring it to a vote and decide if we're going to actually defer it, and that's more likely what's going to happen. No, well, you don't have to. I'm sorry.
No,
He asked for the defer. Okay. So what you need to do now is, after we get together, we're going to make sure that you talk to Ms. Working or staff members to figure out what time.
Ask him how much time he thinks he needs.
Well, how much time you think you might need?
I don't know.
90 days?
Yeah, 90 days should work.
Gonna work, Ms. Working?
Probably wouldn't be till June.
Okay.
I mean, I'm not in a hurry. I just want you to have the facts so that you know what we're dealing with here. Mr. Boykin was indicating he might know, might not know. We kind of went back and forth.
Sir, if you're asking for a deferral.
We'll grant it to you.
That's,
I'm just asking for
yeah.
deferral. Yes, sir.
So
That's it.
at this time, we'll grant you the deferral, and what we'd like for you to do is to meet with staff after the meeting and get more details on when you can get that, okay?
Thanks for your time.
All right?
Okay.
Thank you.
Good.
Case is closed. Our next case tonight will be case BZA 01-22-00.
Need a bathroom break.
If you don't mind, folks, you can just have your conversation on the outside of the corridor, please. So we can continue.
Chairman, Mr. Chairman, can I request a recess after this case for maybe 5 minutes? Thank you.
Take it. Does anyone need a break now, other than Mr. Marchant?
Need one, but I can get through this case.
I tell you what, we're gonna have a 10-minute recess, and we will resume at 6:43, okay?
There you go. Stretch a little bit, right?
If I can get your attention, please. At this time, we're about to start our meeting again. And the next case that we have tonight is case BZA 01-22-0054, and that will be done by Mr. Joshua Dowie.
All right, good evening, everybody. This is BZA case 01-22-004-548. The applicant and property owner, Mr. John French, is requesting a special exception to establish a short-term rental, extended home rental in the low-density residential R4 zoning district at 1720 Battalion Drive, TMS number 431-03-00019 on James Island in Charleston County. The subject property and the properties to the north, south, and west are located in the low-density residential R4 zoning district. The property to the south is, the property to the east is undevelopable Marsh. The property contains a 1,793 square foot single-family home with 3 bedrooms that was constructed in 1976 per Charleston County records. The applicant is asking for all 3 bedrooms to be rented for up to 144 days. But please note that the BZA can approve, the BZA's request may restrict the number of days less than 144 in aggregate. That is a picture of the subject property. And again, all the surrounding properties except the property to the south are located in the low density R4 zoning district. That is a zoomed in aerial view of the subject property and a zoomed out aerial view of the subject property. Side note, that is not in your staff report. The Frenches have a very nice view of the Morris Island Lighthouse that staff did see when we conducted our site visit on February the 17th. Staff does believe that all 3 of the criteria have been met for this case. That is a picture of the subject property and the parking. These are some of the surrounding properties within the area. That is Battalion Drive. And so the board may approve with conditions or deny BZA case 01-22-00548, the special exception to establish a short-term rental, extended home rental in the low-density residential zoning district R4 at 1720 Battalion Drive, TMS number 431-03-00019 on James Island in Charleston County based on the BZA's fact finding unless additional information is deemed necessary to make an informed decision. The board may modify any staff recommendations below, including but not limited to restricting the number of days the short-term rental property may be rented. In the event that the board decides to approve the application, the board should consider the following 4 recommendations by staff. And that is prior to the zoning permit's approval, that the applicant shall complete the short-term rental property limited site plan review process. The use shall comply with all requirements of Article 6.8. The property shall not be used for more than 144 days in aggregate during any calendar year. And the board and the property owner shall be responsible for ensuring that the tenants comply with the Charleston County noise ordinance. That is the site plan of the property showing the 5 parking spaces. That is the plat. Any questions for me?
Any questions?
I think you guys might be questioned out after our last round of questioning.
Thank you, sir.
Thank you.
Is the applicant present? Yes, sir. Please come forward. Please state your name and address for the record, and please tell this board why we should approve your application, sir. You can let it down if you like. There you go.
John French, 1720 Battalion Drive. Good evening. I'm here, excuse me. I'm here to apply for a special exception to offer our home on Battalion Drive for short-term rental. My wife and I live in the home part-time and are there monthly. We're here for approximately 1 week out of every month. Our primary residence is in Virginia, but we have two grandsons here under 3, so we don't stay away very long. My wife is a nurse practitioner and works for MUSC. I have recently retired as an ER nurse. We have previously rented the home in 2019 and part of 2020 as a limited home rental. We're here today because of a zoning rule change that required us to apply for the extended home rental. We have a very good relationship with our neighbors. When we rented in 2019 and 2020, we informed them that we were renting the home. We asked them to let us know if there were any problems. I have all my neighbors' phone numbers and they have mine. We had no problems. We typically, I think with the limited home rental, I think you were limited to 70 days. I think per year, we probably typically were right at 60 days. I would be happy to answer any questions you might have, and thank you for your consideration.
Okay, thank you, Mr. French. Does anyone have Mr. Marchant?
Thank you for being here, Mr. French. Any complaints in the past from rentals from your neighbors?
No. Everybody we rented to were basically there. We rent to families, and it's limited to, because of the amount of bedrooms, we had limited amount of people. Our neighbors met the folks that rented there and had no problems whatsoever.
So y'all use VRBO or anything similar? Or is it
We did Airbnb.
Airbnb?
Yes, sir.
Good. That's all. Thank you.
Anyone else? Anyone else? Thank you, Mr. French, for your testimony today. Thank you. Yes. Do we have anyone else to speak in favor of this application? Do we have anyone to speak in favor? Do we have anyone to speak in opposition of this application? Okay, this case is closed to the public. At this time, do we have any discussion, questions? Okay, I guess I need a motion then, folks.
Make a motion.
Mr. Freeman?
So I'm making a motion to approve BZA case 01-22-00548. According to criteria, one is compatible with existing uses in the vicinity and will not adversely affect the general welfare or character of the immediate community. Criteria number 2, adequate provisions made and or exist for such items as setbacks, buffering, including fences and or landscaping to protect against adjacent properties from the possible adverse influence of the proposed STRP use, such as noise, traffic congestion, trash, parking, and similar factors. Criteria number 3 complies with all applicable rules, regulation, laws, and standards of this ordinance, including but not limited to any use conditions, zoning district standards, and applicable STR site plan review requirements of this ordinance, along with the staff recommendation. Prior to zoning permit approval, the applicant shall complete the short-term rental limited site plan review process. And number 2, the use shall comply with all requirements of Article 6.8. 3, the property shall be used as a short-term rental for not more than 444 days in aggregate during any calendar year. Number 4, the property owner shall be responsible for ensuring that tenants comply with Charleston County noise ordinance.
Okay, thank you, Mr. Freeman. Do we have? Thank you, Mr. Marchant. We have a second. Any discussion? All right, let's bring it to a vote. All those in favor, please indicate by raising your right hand and saying aye. Aye. It looks to be that's unanimous. It has passed. Mr. French, your application has been approved. Thank you. It was unanimous. Within 10 days of this application of approval, you will get information from staff letting you know the next step in the process. And once again, congratulations. Our next case tonight is case BZA-01-22-0054, and that will be conducted by Ms. Working.
Yes, hi. The applicant and property owner, Jeffrey McLean, represented by J.D. Collins of Sabine and Waters, Inc., is requesting a special exception for the establishment of a resource extraction mining use in the Resource Management RM zoning district at 7200 Highthorn Road, and that's TMS number 17500000023 in the St. Paul's area of Charleston County. The subject property, parcel B, 30 acres, is adjacent to the north and south, are located in the resource management. They also own parcel that ends in 65 just north, and that parcel is about 65 acres. They purchased the two properties in November 2019 and used the properties as a working farm. The properties are located at the end of Highthorn Road, which is off Hyde Park Road, and the properties to the east and west are located in the agricultural residential AGR zoning district. This is the zoning ordinance requirements. And currently, the 30-acre subject property is in the site plan review process for development of the proposed mine. It would be no larger than 5 acres. There are 2 approved active mines in close proximity to the subject property. There's a mine across from Highthorn Road, and that's TMS 175 and ending in 031, and one east, 175 ending in 022. The applicant submitted their site plan review application in June 2021 prior to the adoption of the revised zoning ordinance in October 2021. Therefore, the June ordinance applies to this application. This is a zoomed in aerial photo of the subject property and zoomed out. Some photos of the general location of the mine on the subject property, some existing structures, subject property, and this is Highthorn Road, and then Hyde Park Road. Let's see. As far as the criteria, we stated that we feel it meets 1, 3, 4, and 5, and that it may not meet 2 and 6. This is the tree survey, and this is the site plan. So the area, the purple boundary is the mine area, the proposed mine area. And this is the approved and recorded plat, and it also shows the ingress egress, which is the Highthorn Road. So if you choose to approve this application, we do have 7 conditions to consider. And one is prior to zoning permit approval, the applicant shall complete the site plan review process. 2, the days and hours of operation for this project shall not exceed Monday through Saturday, 7:00 a.m. to 5:00 p.m. 3, the applicant shall maintain the travelway of Hyde Park Road for a distance of 300 feet in each direction from the truck entrance, free of all dirt, gravel, or other debris associated with the resource extraction at least twice during each workday and once at the end of each workday to maintain a safe travelway. 4, the applicant shall maintain the 25-foot ingress-egress easement, Highthorn Road. 5, the applicant shall be responsible for any damage to roads associated with the resource extraction and coordinate with the state in maintaining and repairing the roads as necessary. 6, the applicant shall post an all-weather sign on the Hall Road entrance visible from the Hyde Park Road right-of-way, listing the name and contact information, including a phone number of the local contact. This person listed shall serve as a contact for this project in case there are compliance issues that arise during the mining operation. And 7, the applicant shall provide documentation from an environmental engineer, geologist, hydrologist, or other similarly qualified professional outlining the effect or impact on the well and groundwater within 1,000 feet of the subject properties. The applicant shall work with the county staff to determine how the owner will mitigate any negative effects if found, or impacts, sorry. Do you guys have any questions? Sorry.
Mr. Borkin?
Ms. Working, I was trying to follow what you said earlier. So this application is not subject to the current ordinance?
Correct.
And it got in how close to when that ordinance took effect, or how far?
It was, they got in June 2021, and the new ordinance is October 2021.
Any more questions? Good observation, sir. Okay, no more questions. Staff. Is the applicant present? Thank you, sir. Please come forward. Please state your name and address, and please tell us why we should approve your application, sir.
Hi, my name is Jeff McLean. I live at 7200 Highthorn Road. My wife and I purchased this property for the sole intent of developing a working farm. It's been our vision to raise beef cattle and catfish, and these ponds are necessary for me to raise the catfish and part of our goal. By doing this, we feel that overall this will have the impact that we want in this area and keep this area mainly rural and farmland. So we feel like it's completely in line with the traditions and values of our local area. And we'd certainly seek to, appease any neighbors' needs or anything that we may need to do. We've offered to maintain the road outright for 6 years. Even though this is only going to take about 8 months to work, but we want to be a better steward to our neighbors and be part of this community, and we want our business to be found on these values.
Okay. I got a question. It's just out of curiosity. What kind of catfish will you be raising?
Channel cats.
Channel?
Yes, sir.
No blue?
Well, the channel cats are actually going to propagate faster. They'll gain weight a little bit better. We've also addressed maybe some of the in-pond breeding rather than just, real stocking. With our soil types that we have, we're going to need some biomass, some infill back in. So we're not looking to just have a giant crevasse that we throw fish in. We're trying to establish a biomass that'll sustain fish and create a breeding environment with some artificial breeding tubes and stuff like that.
Okay. And the pond that you're going to dig, you're going to use that as well for the catfish, or?
That is a catfish
That
pond,
is the
yes, sir.
catfish. Okay, very good. And who's going to use all this dirt?
Sorry?
Who's going to use all the dirt in the mining?
All these new businesses that we're developing in Charleston.
Okay. Yes, sir.
That's a good question. Mr. McLean, how are you, sir?
Very good, sir. Yourself?
I was listening to everything you were saying. If I were inclined to support your application, would you be amenable to a couple of conditions? I just want to run them by you and just see if this would be, we
Yes,
get
sir.
a lot of these, and I am obviously well acquainted with what you're doing, and also the folks that live around you and their concerns. Would you be willing to put a time limit for this? Do you think you need 2 years, 1 year, 18 months to get the material out of there?
So what we're being told under current demand is we could possibly finish this between 6 to 8 months.
Okay.
That's a double-edged sword. We also got to figure the frequency of trucks moving down this road. Maybe faster is not the best. I don't know. I would like to do this as quickly as possible. That's what's best for all parties involved. But I think there's a serious concern if we start exceeding 100 trucks, 150 trucks a day, and I think in our road use agreement, we threw out a big number like 225. Well, that's about a truck every 2 minutes. We live here as well, and we're aware of the volume. We did this to not hide anything. We felt it'd be dishonest not to disclose our full intent. Ultimately, I'd love to have a 20-acre catfish pond, but the first step is 5, and if I can only have 5, I'd love to have the 5. Like I said, we purchased this property with the intent of these developments. We could find no laws, ordinances, or anything on the books that would prevent it. The soil and minerals and available and resources on the property we purchased are ideal for this development.
Do you plan on keeping the water that you pump out of the hole on your property?
No, sir. We've already done if I believe the terminology is Schweppes. We've also, we've been through all the environmental surveys. We've done historical surveys on the land as well. This is, on the edge of a plantation district. We've done everything that we can from wildlife surveys and everything. We found nothing, that we would be impacting negatively, and found that, in the end of this, we feel that we'd be improving the area for both wildfowl, waterfowl, wildlife, and other area wildlife, in addition to our farm animals.
Where will the water that you discharge go?
And I've got JD, my engineer, here with me. He can be more technical. There is a swamp that naturally flows across our property, so we'd actually desediment across the width of our property through a natural low area, and then it would discharge into the swamp and eventually out into another creek.
Well, that was my question. Are you going to have a settlement pond to
Yes,
pump
sir.
into?
There is a sediment pond in the footprint of the mine as required as
Okay.
well. And like I said, this desilting in our scenario is actually going to be longer than what's required in most of the mines as well.
Do you have an objection if we put a condition on this that you won't take any backhaul? Because if you're digging it out to do a
Backhaul is kind of critical to me building the biomass. In this particular area, we're going to have a very white, sandy, high-friction sand. It's ideal for building our roads and building homes on.
Well, maybe I'm not being clear. Trucks that are working a construction site would be coming with material and dumping it back in the hole that you're digging. That's backhaul. Is that? It doesn't sound conducive that you're going to dig a pond and then have backhaul coming and filling it back in. And then the pond's migrating now. It's 5 acres, within that area of disturbance.
Yeah, 100% honest with you, our intent is to do 20 acres of pond, and that's based off 150 acres, 150 fish per surface acre.
All right, did I misread this? I thought it was a 5 acre pond.
Yes, sir. So the last thing that I want to do is represent to you what I'm doing today. Mr. Marchant mentioned that earlier today. He says, if we do this, what are we seeding for the future? I felt it would be dishonest if we didn't say that at the end of this, we will be seeking another permit. But this is a 5 acre permit, I believe, limited to 20 feet, and that is all we're asking for today.
And I guess I'm asking this working. The area of disturbance is how large?
5 acres.
5 acres.
Okay, so that's all, okay, all right. That's fine if you want to come back for another permit. I just want to make sure, a lot of times, obviously, you can get a larger area disturbance and have a 5 acre hole that just moves around the property and just filled in when the trucks come back from the.
No, sir, that is not our intent. Our intent is to build it and not, like I said, not just have a deep channel. This will be infilled, and I don't know if we're going to have enough top sediment. Our topsoil layer is only about 18 inches on this property.
One thing I like to do is try to have a somewhat of a date certain for your neighbors and the folks that live on that road. This isn't just a drawn-out process, and so I'd like to know how many months you think you need to get this material out of there for this application. You can certainly come back for another.
To be conservative, I would say 2 years would be
Okay.
more than fair.
That's fine. Okay, thank you. I was looking for that. Okay. That's all I've got. Thank you.
Good question. He was able to pull out all that information. You ought to be a dentist. You're just pulling all your teeth out.
Been studying this for exam for a while now.
He grabbed you first and just pulled all your teeth out. Anyone else have any questions? Thank you for your honesty and the information that you provided tonight.
Thank you.
Do we have anyone else that would like to? Yes, sir.
Let Savannah Waters go first now.
Thank you. Please state your name and address for the record, please, sir.
My name is J.D. Collins. As they said, I work for Saban and Waters. I live at 1719 Weston Avenue. That's Charleston 29407. I just want to kind of reiterate the fact that the types of land use in resource management, when looking at the comprehensive plan, it identifies timber production, wildlife habitat, recreational, commercial fishing, and limited agriculture. I think it's pretty obvious here that with his plans of doing commercial catfish farming, that falls right into the land use for this type of zoning. Also, to quote the comprehensive plan, designation of resource management areas recognize the importance of a coordinated effort to protect and conserve natural resources while allowing for the continued economic use of private property and public lands. I think this also, what Mr. McLean has stated kind of fits the bill to a T on that also. Just because I know it's going to come up, we've talked a little bit about the truck traffic. I'd just like to say this is a unique property in that not only do we have the more direct route to Charleston, down Hyde Park and then to County Line, but we're also in a good area where we can access other areas via 165 and Highway 17. There's also a lot of planned developments, Dorchester County, where we're located here. It's a short distance for trucks to access some of these developments off of 165 as far as, when we're talking about selling the dirt. Less time on the road means, less opportunity for something bad to happen. So, also like to state that we have all of our approvals from DHEC Mining on the state level. We have a jurisdictional determination from the Corps of Engineers. We've got land disturbance permits from DHEC, and we also have coastal zone consistency from OCRM. So aside from the approval we're seeking here, we have everything else we need to go to work at this time. Any questions?
Thank you, sir. Anyone have any questions? It's pretty thorough. Thank you so very much, sir.
Yes, sir.
Do you really, do you want to say something? No, please come forward. Please state your name and address for the record.
Nicole McLean from 7200 Highthorn Road. I'm sorry, I'm really bad in front of
No,
people.
you're fine. Go ahead.
I just want to read my letter. There seems to be some misinformation in the community about what we're trying to do on our farm, and we'd like the opportunity to clarify the situation for our neighbors. We are not a corporation or a developer looking to turn the property into a high-density development. We are a husband and wife who have put everything into buying a farm. To turn it into our forever home. We live here, and I left my full-time job to be at home here every day. Work the farm and take care of the animals. We maintain and care for 9 rescue horses, a heritage herd of Watusi cattle, and a small herd of Angus beef cattle. We've gone to great expense and focused all of our time into improving this property over the last 2.5 years, and hope to continue that with the plan we have for the ponds. Over the next few years, we anticipate adding blue catfish, channel cats, with the addition of the ponds, along with fruit orchards and a small olive grove. We are doing our best to try and sustain a large working farm in a modern world, and these ponds are necessary to our way of life. We would ultimately like for our farm to be self-sustaining through what we raise and grow ourselves, and provide the community with local and ethically sourced beef, fish, and honey, along with providing a sanctuary for our rescued horses and heritage-bred Watusi cattle. The revenue from the extraction of the sand is instrumental in facilitating this. Once finished, the ponds will be where our channel cats are raised. The ponds will serve as a natural source of fresh water for the wildlife and our livestock. They will support and enhance the natural environment for birds, waterfowl, and plant life, and there will even be a separate therapeutic swimming area for the rehabilitation of our rescue horses. While this permit covers 5 acres, the full plan involves 2 different ponds, and originally the hope was to have it all completed in a relatively short amount of time, over 2 years or so. However, with COVID and the fact that the permitting process itself is relatively lengthy, we pushed the full time for completion to 6 years as a high-end estimate. It will not take 6 years of actual digging. The vast majority of that time is administrative, and there will be no dump trucks running during that time. Of the 2 homes on Highthorn Road, we are one of them. The other home belongs to our neighbors, the DeCarlos, who are in full support of our plans. We have signed a letter agreeing to improve and maintain Highthorn Road for 6 years, even if dump trucks are not running. I believe a copy of that letter was already submitted, and there will be a sprinkler system and a water truck to mitigate dust on the road. We love our farm, our neighbors, and our rural way of life. Developing our property in this manner for agricultural and aquacultural use ensures that we will be another large farm that can stay intact and prevent more high-density housing in the area. Thank you so much.
Thank you for your testimony. Does anyone have a question for the applicant, co-applicant?
I'll just say something real quick. You had me at horses.
Come see him anytime.
I'm glad you addressed the dust issue. I think mines have come before us before, and always the concern is how it impacts the quality of life of residents, and noise, dust, and the increased traffic always comes up, so.
And this is going right next to my house and my animals, so there's no way I would ever let that be a problem. So.
Anyone else? Thank you so very much for your testimony. Anyone else in support of this application? Anyone in opposition of this application? Okay. Please come forward, state your name and address for the record.
Dustin Cole, my address is 9617 Roseberry Street. My wife and I own
State the address again, please.
9617 Roseberry Street, Ladson, South Carolina 246. My wife and I own the frontage portion of the property through which the proposed mining operation will run. We stand vehemently opposed to the sand mining operations for several reasons. This operation will be moving through the middle of a shared private easement that is approximately 25 feet from where I work and where my family recreates on a very regular basis. This will not be moving through a public roadway. My family, our 3 honeybee colonies, and the other wildlife that share our land will be directly exposed to any and all aerial debris, dust, and hazardous particulate created by the mining trucks in their general daily operations. We're concerned about the waste runoff. The yellow line to an end. Well, where does that go? We got a creek that runs through the front of our property. When that finally, the topography, we don't know the topography. Is it such that it won't settle in my creek, or will it settle in someone else's creek? And, you know, they keep using the word neighbor. We heard from them 6 months ago with an agreement for 6 years of use, 120 trucks a day, and we haven't heard a word since. So ain't nothing neighborly about this. We purchased this land in hopes of building a home and growing with the community of Ravenel as well. Our land has a pond with bass, brim, and catfish. We have resident deer, turkeys, and currently care for 3 young and thriving honeybee colonies. We very frequently share meals and have gatherings out there with our family and friends. I have an outdoor hobby shop where I'm constantly working. We have plans of expanding our honeybee operation this year and hope to add goats and chickens to our farm as well. These mining operations will very certainly hinder and at times possibly even restrict my family's ability to access and safely navigate and enjoy what we sacrificed for and worked so hard to obtain. My young kids, their cousins, and their friends ride four-wheelers up and down this road. They want to drive 180 trucks down for 6 years, 6 days a week. We got to understand that is none of you guys would approve that if it was your land. We're not opposed to a pond. This has been dressed up as a bass pond, catfish pond. That's not what this is. If you give him 15 permits, he will dig 15 ponds. This is going right through the middle of my property. They have to go through the middle of my land to get to their mine, and they're going to drag it back and forth past all my equipment, all my bees, all that stuff. It's a gross infringement of our privacy as citizens and property owners. None of this is taking my family, our safety, our goals, our investment into consideration. The applicant appealed to the county by stating they put it all on the line. We're 38 years old, barely 40. That was a big investment for us too. It's all on the line for us as well. Our goal was to move forward with a farm to enhance the farmland of Ravenel as well. But, you know, money in the pocket, I guess, feels like my dreams and my goals are being pushed to the side. That's all I got to say.
Okay.
We would request that they find, there's plenty of land. I mean, there's so many alternative routes. We would even be open to negotiating, possibly cutting another route away from our buildings, away from our bees, on our property. Since their neighbor is so on board with them, they shouldn't have a problem, you know, dedicating some of their land to some of their mining activities as well. We just don't want it coming past our front door. We don't care what they do. Take it out by helicopter.
Okay.
Thank you.
Wait, hold on, sir. Hold on, sir. Let me help you. Where's your tax map number again, please? Okay, so that illustration there, where does your property sit, sir?
Okay, so where the pond is, the dotted line, that's my property in the front. Their mining operation is in the back here. I own the left side and the right side.
Okay.
Is that parcel A?
Parcel A.
So your property is parcel A?
Yeah. 175000064.
Here.
Yep.
Okay.
Now, is it,
Hold on. You got 61 acres over there? Is that?
36.
36? Go ahead, Ms. Smalls.
I just wanted to ask, help me understand how is he going to be going past your property or through your property? It doesn't seem legal for him to.
Through and past, however you want to. We own the front part, he's in the back. Our roadway, he drives between the right side and the left side of what we own. He comes right past my buildings, my equipment, my bees. I don't know how this is even considered.
Where is this? It's a public roadway, though.
This is a private roadway, privately owned, shared easement.
And
me, the neighbor that is so graciously loving what they're doing, and then them.
okay, hold on. Where is your house in retrospect to this? Maybe I'm not
We have
seeing.
a camper, I'm sorry. It's not a home. I apologize, we don't have the money to do all that right now, but, you know.
You have a camper on the property, sir? Okay. Does anyone else have? Yes, Mr. Boykin.
Good evening, Mr. Cole. Do you live on your property, or is it a place y'all go and recreate?
Very frequently. I'm there 5 days a week.
Where do you live?
I live in Matson.
Gotcha, okay. And the roadway, I guess, is it a deeded I guess it's a deeded easement, but it's for all those parcels to go get ingress.
sir. Yes, sir.
And when you bought your property, that easement was already in place?
Sure. Yes, sir.
Okay. Tell me about your pond. How long has your pond been there?
I believe it's estimated like 3 to 5 years old.
Did you dig it?
No, sir.
It was already constructed on the property
Yes,
when
sir.
you bought the property?
Yes, sir.
So was all that dirt left on the property or was it hauled away?
I don't know. There's a big hill, so it may have been left on the property.
How big is your pond?
My pond is approximately 1.5 acres, 2 acres.
Okay, all right.
It's not even 6 feet deep.
Okay. We
did not mine sand from
Sure.
mine.
I've lived around a lot of sand mines, dirt pits, whatever you want to call them, and one went right down the street from my house. It was 5 acres, and they had that thing emptied out in less than a year. It was done, because it's not a big hole. So
The only terms we've been given is 6 years, 180 trucks a day.
I know, and that was an estimation, and I get all that, and that would make me concerned as well. Are there any provisions tied to that easement that prevents commercial use or industrial use of that easement?
We've been flexible since day one. I think just lack of communication has us standing here tonight.
Well, is the easement in writing? Is it recorded?
We all have access. He has to have special permission to go above and beyond what is considered a normal egress and ingress, right? I mean,
Maybe you misunderstand me.
Okay, yes, sir.
Usually when there's a deeded easement, there should be some recorded instrument that says what the conditions of that easement are.
We have that. So, yep.
Do you have a copy of it?
No, I mean, I can show you a picture of where, you know.
Yes, sir. Give me 1 minute, indulge me, please. Thank you.
So while he's looking at that, where do you normally park your camper?
The camper is parked right there by the second H in Highthorn on that map right there.
Okay. So it's
my barn is the I after the H.
okay. So your barn was it permitted? Well, I guess.
Yes, it was permitted.
Okay. I guess we were looking for that on there. At least I was looking for that on there.
I got it.
Okay. Did you have a follow-up question,
I
Mr.
do,
Borkin?
yes, sir.
Okay, go ahead.
Mr. Cole, I'm looking at the title to the property in question, and it does provide ingress and egress, but it doesn't put any restrictions on that ingress. It doesn't say they can't use it to haul dirt out of there.
Sure.
And I mean, you bought your property somewhat recently, and I guess they have as well, so I get that. That's one of the reasons I was trying to lay some of these concerns. You mentioned the silt and the sediment. DHEC requires that they have a settlement pond when they do this, where they pump the water out of the hole. It's got to sit there, and then it drains out, or pumps out, however they got it set up.
Awesome.
But it moves like in little basins, and I'm well acquainted with this process. And that lets the sediment settle down the bottom, and the water only leaves out. That's the way it's supposed to work. DHEC comes out and does inspections. If there's an issue with it, you can certainly call them. They will come out there. I know because we've had issues near our place with adjacent landowners, and they do respond and they handle their business. One of the things I was looking at and potentially approving this is, asking about the backhaul. And they've got a 5-acre area of disturbance. They can have a 5-acre hole. They can't let this thing migrate and go on forever. And if I were to make a motion, I would include a 24-month limitation that they would not be allowed to remove any more material from their property at the end of 24 months of getting the approval from this board, if that happens, to give you some sense that this can't go on forever. Now, you said give him 15 applications, he'll dig 15 holes. Well, he's got to come back here each time, and there's also...
We'll have to be here each time to...
Well, hang on, hold
Okay.
on. There's a difference here.
Sure.
You heard Ms. Working state earlier, had their timing not been what it was, they could not even come before us right now because there are other 2 active mines within 2.5 miles
Sure.
that precludes this from happening.
Sure.
So they can dig this one, but once this one's done, if those other mines are still going, you don't have to worry about this because
Okay,
they
so
can't get another permit.
So I guess in retrospect, in closing, the county is okay with this moving through a private easement?
County has nothing to do with the private easement. Got no authority to regulate it whatsoever.
So if we needed to take, repercussions against them, there's nothing you guys could do for us.
That's a court issue, sir.
Sure.
This board has no authority.
All I've told you is I've reviewed their title to real estate, and there's no restrictions on this titled real estate for their ingress and egress. And then again, that's not a matter for this board. If I read something to say no commercial, no industrial, no dump trucks, that would be a different matter entirely.
Thank you guys very much. Yeah.
Okay, yes, sir.
Hold
Thank you.
on,
I'll
hold
go
on,
to anybody else.
hold on. Does anyone else have any questions? Mr. March?
My only question is, are there any concessions or allowances that you would offer to allow this gentleman and his wife to do this? Or is it no?
Yeah, like I've said,
period?
if you look behind you there on Highthorn Road, there's two empty squares of property right there. We haven't been able to talk to them because they ignore us, but we would actually let them cut trees down off our property to move sand away from where we recreate. We are giving up a portion of what we paid for to let them do it without disturbing us. Yes, we are very flexible.
Thank you.
Yes, sir.
Anyone else? Thank you for your testimony. Do we have anyone else that'd like to speak in Yes, ma'am. Please state your name and address for the record.
My name is Lauren Cole, and I live at 9617 Roseberry Street in
All right, Ms.
Ladson.
Cole, we also have a letter of opposition here for you, correct?
What's that?
You also have given this board
I did
a letter of
send
opposition.
I did send an email to the director. Yes.
Okay, Mr. Evans, that's correct. So you're going to tell us something other than what you have on this, in
Other
this
than
letter?
what he said.
Well, other than what you have in this letter that you submitted. You can, I'm just saying.
Well,
Just
I
listening.
would just say that we have rights to egress and what's the other word?
Ingress and egress,
and
yes, ma'am.
egress. And this may prohibit that. If trucks are lined up and we can't get in our land, that prohibits our ingress to our property. If there's trucks coming down the road, we can't egress from the easement. This is a single point of access. And again, we would change the point of access for them. So we just don't want it running through the middle of our land. To your point, the dust this creates, if we're out there playing with our kids, fishing with our kids in our pond, we don't want dust. We don't want dust in our food when we're cooking out with our friends and our family. We don't want to keep them from doing what they have to do or they want to do on their land. What we don't want is 6 years, 20 acres, which I realize 20 acres, but they express that intent, right? That is what we're here trying to avoid. And that's what we're asking y'all's help with, because we intend to build out there. We intend to have animals out there. And I don't think our use of land is any less important than theirs. So I don't, it's running through the middle of our land. It affects our ability to use our land. If it didn't, we wouldn't be here, because we have been here for 2.5 hours just to state this case. So I appreciate y'all listening. We're very passionate about this. We did work hard to get this, just as I'm sure they did. I'm not saying they're wrong. Us not wanting it is not wrong. But there has to be something in the middle here. The way it stands is just not okay.
Okay, Mr. Cole.
May I say something? I'm the board's attorney, so I'm not giving you legal advice. Parties in a transaction such as this can come up with an agreement. This is a private easement over private property. You've both expressed a willingness to discuss it with each other. The easement can be moved, and that's an option that you all have. I'm not saying that as an attorney to you all, and that's not the board's recommendation. But given what you've both expressed, that is an option. Obviously, you would need to get the other party involved because
We'd have to be able to communicate.
Well, the board has nothing to do
I
with
know
that.
you have nothing to do with that, but that is the fact that we can't communicate at this point is what led to us being here trying to stop it, because there.
Well, so I will say this. You have the opportunity as adults
I
to
agree
attempt
with
to
you,
communicate
100%.
or leave it up to the board to make a decision based on the criteria that are before the board.
Okay.
That's y'all's choice. And actually, I'm not telling either side what to do.
No, I agree with you 100%.
I believe that you are both looking for the best use, current and future use of your properties. Just a little FYI.
Did you understand everything that Mr. Hughie, Attorney Hughie just said?
I did.
Okay. Do we have anyone else to have a question or comment?
Just
Mr.
real
Boykin?
quick, just real quick. Ms. Cole, I am sympathetic with your plight. Unfortunately, you guys have bought a piece of property that the easement ran right through the middle of it. And so everybody behind you, it's kind of what you signed up for because you can't control, they have as much right to use it as you do. Unfortunately, yes, you're right. It's coming right through the middle, but that's how you bought the property.
But we did not buy it knowing that we would have to breathe in dust for 6 months and not be able to use our land. So I would argue a little bit with what you're saying. Yes, we bought with an easement through the middle of the land. You are correct. There's no disputing that.
But you would also agree with me that somebody dug your pond and hauled dirt in and out of there as well.
It was a single private easement.
Please,
It was a
sir.
single private easement when that pond was dug. He subdivided that land after he dug the pond.
But so the developer decided where the easement was going to be. And y'all bought
The easement was already in place.
I understand, but y'all bought the property as is, where is. And so, again, you know, they have the right to use the road. They also have a right to utilize their property. And this is an issue of balancing property rights. If y'all were to
have
put the
the
shoe,
right to
I
use
understand,
ours.
put the shoe on the other foot. If you
I
were
have a million times. I have.
I know, and so you have a pond. They want a pond.
They don't want a pond.
Well,
Pond doesn't involve.
that's what they're applying for.
No, they're applying for resource extraction. We were told by the county that a pond, the dirt stays on site.
That's correct.
This is not a pond. They're
Right.
taking dirt off site and having to backfill. In my mind, that's two different things.
It is two different things, but they also have a right under a special exception, should this board grant it, to do it, just as y'all would.
But what are where they may not meet? What are those that she listed? The
So that's
criteria?
one thing the board has to determine. Okay?
Okay.
So I'm going to kind of end it at that.
Okay.
Does anyone else have a question of Ms. Cole? That's okay, that's okay. Ms. Smalls?
Or maybe this is a question for your husband. He mentioned that you all offered a portion of your property as a different means for them to get in and out to build their pond. Is this like temporary, or are you willing to sell to him, I guess, to?
No, it wasn't.
Point.
It wasn't to sell. It was
Temporary.
to lower the impact on our property. Was to move it. But we haven't had that conversation with them because since we refused to sign the road use agreement, there's no communication now.
Okay. Anyone else? Good question. Anyone else? Thank you, Ms. Cole, for your testimony.
Thank you.
Do we have anyone else to speak in opposition of this? Yes, ma'am, I see your hand there.
My name is Melissa Barfield. I live at 6964 Kynard Road, which is not even half a mile from where they will be digging. They're asking for the first 5 acres. From my understanding, that's all
correct.
they're asking for. He's making the comment that he's going to do 20 acres later. Mr. Boykin, you said that he can't
Hold
come.
on, so we're not going to just ask questions. You make a statement and then,
So my statement is, can he come back later if the mine across the street that's, you know, because you have the 2.5-mile radius law that you put in effect in November. Can he come back when that mine closes across the street because it won't be in a 2.5-mile radius from where a current active mine is and get another permit for another dig of 5 acres?
Mr. Hughes, you want to answer that?
If he applies and the regulations allow for another mine, he's welcome to apply. This board doesn't control whether or not he can apply to do another mine 2 or 3 years from now. That's completely up to whatever the regulations say. As you've heard earlier, they applied in time for the current
Correct.
resource extraction. Had they waited 4 months,
They would have missed their
they
opportunity.
would have missed their opportunity. So that's not before the board. The board has no control over that.
So can I ask for a stipulation to be put in that they cannot ask for no more than 5 more acres?
You can ask, but that cannot be enforced.
And why couldn't it?
Because if that contradicts what the law is at the time, it's invalid. That would be struck
So it
down.
wouldn't be able to do it. We'd have to come back again if he asked for 5 more acres, if he does.
Yes, ma'am. It would be your right to come back.
Okay, well, I'm just letting you know I oppose it. I live there. I've lived out here for 24 years. We have dump trucks already that go up and down that road at 50, 60 miles an hour. And now he's wanting to bring hundreds more on top of the 2 mines that are already there, that already have trucks on the road. So the impact study on Hyde Park Road, whether he takes it from Hyde Park to County Line to Kiner to 165, there's dump trucks everywhere now because there's going to be 3 mines. So I'm just opposing it.
Okay. Thank you. Thank you for your testimony. Does anyone have, Mr. Boykin? I looked that way and he's right there.
I'm going to do my best to clear this all up for you. I'm hearing everything you're saying and listening attentively. So county council passed an ordinance, 1 mine per 2.5 mile circle.
Correct.
But everything that existed before is grandfathered in. Good enough on that. But for their timing of their application, they would not even be here tonight. So they applied under the laws that existed at the time. They have a right to be heard here, and they have a right, if it meets all the criteria, to be granted this time. I don't know how long those other mines are going to last, how long they're going to play out. So long as either of those 2 mines, not both, just either, exist, they'll be precluded, barred from coming and applying to this board for another permit.
So they'll be back
is that
because
clear?
I can tell you the mine across the street from them is just about done. Their
Well,
time
then,
is
all right,
just-
scratch that one. There's still another, Ms. Working, was that correct? Or
Yeah,
Ms.
but I don't think it's
Was there
100%
2 mines with
active.
There was 2 mines there.
It's correct.
Okay,
There's
so
another
there is
one
another mine.
adjacent.
No,
They're not active right now.
but that doesn't matter. As long as they have BZA approval and DHEC approval, it's still an active mine, whether they're hauling or not. You get
It's
but-
still
right.
considered an active mine.
Yes, because DHEC has to come in and close it. There's a whole process for that. But anyway, what I'm getting at is he can't keep coming back if there's another mine in operation. And if he does come back and there's, these criteria are not met, then he may not get approved. Or someone else applies for a mine that's somewhere else out there. So there's all those factors. We can't predict the future. But I just wanted to try to allay some of your concerns. It's not like he can just pop right back.
Right, and that's
it's
what I
going to be
don't
an
want to see.
automatic
I don't want to
thing.
see it
No.
continuous. If he wants to do his 5 acres to do his catfish and sell that dirt, that's perfectly fine, but I don't want to be a continuous
And I feel your
thing.
pain. Those roads are absolutely overloaded out there, those huge mines on county line.
Loaded.
I'm well acquainted. Yes, ma'am.
And to have 3 mines that close to each other already, and you're going to have 200 more dump trucks or 100 more dump trucks on the 100 that's already there.
Well, that's why Charleston County is trying to fix it with this change to the ordinance, to try to give you some relief.
Thank you.
Thank you. Does anyone else have a question of this young lady? Thank you for your testimony.
Thank you.
Do we have anyone else to like to speak in opposition? Okay. No, you had your opportunity. But thank you for asking. At this time, sir, you have the right of rebuttal, and you have 2 minutes to do so, sir. Please, once again, state your name and address for the record, sir.
My name is Jeff McLean. I live at 7200 Hawthorne Road. To address a couple of the bigger concerns, when we bought this piece of property, we were introduced to this property through Amory Inglis, the local realtor. The Coles were aware at that time during purchase what we were using the property for even before they purchased it. They purchased approximately a year, maybe a year and a half behind us. All of that being said, it doesn't mitigate their rights to peace and happiness, and we understand it. They have made zero attempt to communicate with us at all after seeing this road use agreement. They stood here today before you and lied. I am open to any and all communications. Unfortunately, they don't own any other access through to Hyde Park Road. This is the only way that we have out to the highway. I hear everybody's complaints in this and everybody's concerns with this. And I don't want to be an impact, but this is, in our essence, a battle for our existence. We've exhausted our resources trying to come to this point. This has been a little over 2 years in this. We're asking for a 5-acre permit. We know there's no promises on the future, but that is all we're asking for today. If in the future, if there is other communications that we could, create with our neighbors to make a less or lower impact that would facilitate some of our future plans as well, then that would be awesome. We're open to all of it.
Okay. Thank you so very much. I think Mr. Boykin has a question or
And I hope this will work for the Coles benefit as well. Mr. McLean, you say you do have your DHEC permit in hand?
Yes, sir.
The trucks that will come onto your property, do you have sufficient room on your property, not the ingress and egress, for all those trucks to stage?
Yes, sir. I have approximately a quarter mile of Highthorn Road that's exclusive my property. There'll be no trucks staged in front of them. I know there's a law that says they can't enter the property before 7 a.m. There'll be no idling trucks. There'll be no aggregate trucks waiting to start in this mine. We will also be living here, and I can assure you anybody hauling on and off this mine will be obeying speed limits and all traffic laws.
Did DHEC require you to provide for dust mitigation with a water tank to wet down the road? Because we've run mines on our property, and I know that was a requirement, and we had to abide by that.
It is absolutely a requirement and also one of our requisites in order, we didn't just turn this over to a developer to dig this and we were going to get the finished product. We kept my name on top of this because we want to be in control of this development rather than a rogue builder out there. We've seen it. We've seen ponds dug too deep. We've seen ponds dug too big. We've seen...
I'm considering supporting your application, but I'm going to ask you a couple more things. One, I would include that you be responsible for wetting down that ingress-egress road to control the dust for the coals, because I know how it is. I've seen the trucks roll, and they do make a lot of dust.
Absolutely.
All right.
I've also reached out to our neighbors at Carlos who have a closer access point to a well, and we talked about putting in a drip line on timers so that we didn't have to depend on just a truck driving down there 3 or 4 times a day, which I find construction sites tend to get busy and don't always do all their work. But this would be an automatic.
You need a water truck or a water tank with a sprayer on the back of it to wet it down for dust mitigation. So I'm inclined to support your application. The other thing I would ask for is a modification of your days of operation to make it Monday through Friday, not include Saturday. So if the coals are coming out there trying to enjoy the property on the weekend, they don't have to be disturbed by the trucks. That's why I asked where they lived. I'm trying to get an idea of what their expectations are. They're not living there yet. And I want to put the 24-month time limit. Would you be amenable with those conditions?
Yes, sir.
Okay. All right. That's all I have. Thank you.
Also, would you be willing to make sure that there's a sign out at the staging area with your contact information and contact information for anybody
Yes,
that's
sir.
working with the truck?
Yes, sir.
With an active working at all times number?
That one right here.
Okay.
You want it on the record? I'll read it off now.
Well, why not?
843-296-1558. This is my everyday carry phone. It is my cell phone.
Do you have an alternate number?
843-571-5735. It's my place of employment. I've been there 20 years.
Thank you, sir.
That was actually condition 8.
Okay. Say again?
That was actually contained in condition 6, I believe.
Yep. I just want to make sure you put it out there.
I'm going to put all of them, yeah. Sorry. Yep, got it.
Does anyone else have a question or comment?
One quick question.
Yes, sir.
So you mentioned 20 acres additional. Is that, how much time would that take if you wanted to?
I'm sorry, what?
How long would if you wanted to continue coming back again and doing another 15
with
more
the
acres?
current ordinances and everything in place, I don't know how long it'll take. I mean, this, may be the only step of our dream we get to develop is the reality of the hearing I'm hearing today. So, Lord willing, county willing, we'd love to do it in 6. I don't think it's feasible from what I'm seeing today. We'd be grateful to have the 5 and abide by any future laws that we have to.
All right.
All right, thank you.
Thank you so very much. You may be seated. You may be seated. Thank you. This case is closed to the public. Questions, comments, discussion? Okay. Then I need a motion to either approve or disapprove case BZA-01-22-0054. Do we have someone that Mr. Nelson, you looking at me, or like you want to? You looking?
Has a pretty good handle on it. All right. Mr. Chair, I'll be happy to make a motion, sir.
Thank you, sir.
In the matter of BZA case, BZA-01-22-00549, I move that we grant the special exception for resource extraction. Find that it meets criteria 1. It is consistent with the recommendations contained in the Charleston County Comprehensive Plan and the character of the underlying zoning district as indicated in the zoning district description, based on staff's report and testimony we've heard tonight, and both from the applicant and also those in support and in opposition. It meets that requirement. Criteria 2 is compatible with existing uses in the vicinity, will not adversely affect the general welfare and the character of the immediate community. I find that it will meet that criteria, especially with the conditions I'm going to put in my motion to assure that. Criteria 3, adequate provision is made for such items as setbacks, buffering, fences, and landscapes to protect adjacent properties of visible adverse influence, proposed use, noise, dust, and vibration, glare, odor, traffic congestion, and similar factors. Again, with the conditions that will be applied to this to see that criteria is met. Criteria 4, where applicable, will be developed in a way that will observe and incorporate any important natural features. It doesn't interfere with any of that. Criteria 5, it complies with all applicable rules, regulations, laws, standards of the ordinance, including but not limited to any use conditions, zoning district standards, or site plan review requirements of this ordinance. It meets that. Criteria 6, vehicle traffic and pedestrian movement on adjacent roads shall not be hindered and endangered. Conditions will cover that, and the duration of said operation will also assure that. So those are all the 6 criteria. It meets them. The following conditions I will include in my motion. Number 1, prior to zoning permit approval, the applicant shall complete the site plan review process. 2, and there's a change here, the days and hours of operation for this project shall not exceed Monday through Friday, 7 in the morning or 7 a.m. to 5 p.m. Number 3, the applicant shall maintain the travel way of Hyde Park Road for a distance of 300 feet in each direction from truck entrance, free of all dirt, gravel, or other debris associated with the resource extraction at least twice during each workday and once at the end of each workday to maintain a safe travel way. 4, the applicant shall maintain the 25-foot ingress, egress easement on Hawthorne Road, and I will add this additional requirement to number 4 to include water application as required for dust mitigation on Hawthorne Road. Number 5, the applicant shall be responsible for any damage to roads associated with the resource extraction and coordinate with the state in maintaining and repairing the roads as necessary. Number 6, the applicant shall post an all-weather sign on the Hall Road entrance visible from the Hyde Park Road right-of-way listing the name and contact information, including a phone number and of the local contact. This person listed will serve as a contact for this project in case there are any compliance issues that arise during the mining operation. Number 7, the applicant shall provide documentation from an environmental engineer, geologist, hydrogeologist, or other similarly qualified professional outlining the impact on the well and groundwater within 1,000 feet of the subject properties. The applicant shall work with county staff to determine how the owner will mitigate any negative impacts if found. And then I'll also include number 8, which will be that all resource extraction will be completed no later than 24 months from the date of the approval of this application. And I think I've addressed everything. Mr. Chair, that is my motion.
We have a second?
Second.
Okay. We have a discussion. Mr.
Question regarding your last point, approval of application. Would you be okay with changing that to commencement of work?
That's fine. Mr. Chair, I will amend mine to change the language for that not the date of approval, but change that to date of commencement of work. All right. That's fine.
Okay. Any other questions, comments?
Do we need a second on that or change?
Ms. Smalls always,
Oh,
yeah, well.
thank you.
Ms. Smalls, you go along with that change?
I second the change.
Okay, all right. So at this time, let's bring it to a vote. Any more comments? No? All right, just had that look on your face. All those approve this application? Please raise your right hand and say aye.
Aye.
Aye. Any opposed? It's unanimous. Congratulations, sir. Within 10 days, you'll be getting information from staff, letting you know the next steps in this application. Thank you once again, and please, sir, remember to communicate with your neighbor in a nice, friendly manner. Peace and harmony, okay? Thank you. All righty. So our next case will be completed by Ms. Working. This is case BZA-01-22-00550.
Okay. The applicants and property owners, Benjamin Pantuck and Helen Pantuck, are requesting a variance to reduce the required 50-foot OCRM, and that's the Office of Ocean and Coastal Resource Management critical line setback, by 15 feet to 35 feet for a proposed swimming pool at 1980 Long Creek Road, and that's TMS number 217-000090 on Wamala Island in Charleston County. The subject property and surrounding properties are located in the Agricultural Preservation AG 15 zoning district in the Long Creek Plantation subdivision that was platted in 1991. Charleston County adopted required setbacks and buffers from the OCRM critical line in 2001. And these are the current regulations. Zoomed in aerial and zoomed out. Some photographs of the subject property. This is the rear and the side of the property. And then the front of the property. As you can see by the aerials, it's a pretty long piece of property. And this is Long Creek Road. This was a sketch he provided that shows the approximate location of the septic system and some aerial photographs. And again, several of these pools were permitted prior to the critical line regulations. Let's see. As far as criteria, we thought that it may meet, or that it meets 5 and that it may meet the other criteria. Let's see. And we did have a couple conditions for this one. Prior to commencing construction, silt fencing shall be installed along the critical line. The silt fencing shall be maintained for the duration of construction. 2, the applicant shall use stormwater mitigation measures such as the use of rain barrels or rain gardens to reduce the flow of stormwater into the marsh. And 3, the encroachment area shall be limited to the footprint areas shown on the submitted site plan. These are some of the drawings of the pool and site plan. This is the survey of the current property and then the plat. Do you have any questions?
If I'm reading this right, so they will be outside of the critical line buffer, correct?
Well, it would be right at.
Yeah.
Yeah.
Right to it.
Yes, correct.
Okay.
They would be maintaining.
They don't
the
need to
buffer.
remove any of the critical line buffer.
Right,
Thank you.
correct.
Okay, I'm sorry, I didn't say it right. Sorry. Does anyone have any questions for staff? Okay.
Mr. Chairman. Which line is the critical line? I'm just having a hard time reading this site plan. I apologize.
It's okay.
Maybe you can.
Relatively quick.
This plan shows it a little better. Because it goes up the side, but also to the rear. Can you see it?
Not really.
In your packet? Do you want me to?
I'm looking at the one with the septic tank marked and the leach
Oh,
field
no.
marked. You what? Where am I going?
To the drawings back here.
Ah,
It's
big
okay, it's a long
drawings.
night.
Thank you. Thank you.
Any more questions of staff? It's working? Thank you. You finished up a little bit faster than I anticipated. Okay, there being none, is the applicant present? Would you please come forward, state your name and address, and please tell us why we should approve your application, sir?
Good evening. I'm Ben Pantuck, 1980 Long Creek Road, Wadmalaw Island. I think you should approve my application because my wife and I would love a pool, but this is the best location and basically the only location on our lot that is usable for a pool. We want privacy from our neighbors, and you can't see it on the thing, but to one side behind our house is our neighbor is constructing a home, so they wouldn't be able to see it from there. And on the other side of our property, their septic system is there and all that, and so that's not a good place for a pool either. And if you went farther away from the house, it just wouldn't be close enough to the house to be practical, and there's a lot of trees that would need to come down. And as you could see on one of those drawings, there's kind of like a little jut out in the critical line area that is actually, used to be farmland, I believe, back in the day, but that was like a drainage ditch. So we think it was kind of mistakenly included in the critical area in the first place, and if that piece wasn't there, it would have fit within the 50-foot setback, we believe anyways. And on the survey that we based our plans on, 50 feet wouldn't have been a problem because that was not included in the survey from, I think it was 2015. But we had to get it updated to apply for the permits, and here we are. So I'll take any questions.
Okay. Let's see who has any question for you. Mr. Borkin, you got one or two?
Mr. Pantuck, and again, I'm trying to keep up with this. So you had a plat to start off with. Did that first plat that y'all had for the property show the critical line at that time, or did y'all not get the critical line established till you did the most recent plat?
The critical line was on both. I think it was in this packet I submitted. There was one from 2015. Well, it was in my correspondence. I believe I submitted it with the application. I'm sorry, I don't know the best way to have you find that, but you can see the critical line has evolved over time, which is obviously things happen and all that, but we think it included this drainage ditch between the dock and our house. So, okay, well, that's the one from 2015, I believe, and that's the critical line on the right side. And it's just pretty like smooth towards the house. The X through that building, that was the builder's original plans, but he didn't do that. So our home is just that one on the south side of the property, I guess.
Okay, so we've got the X'd out one that
does not exist.
Does not exist, and the proposed one that's written on your notes here, that does exist yet or no?
Yes.
Okay, so that's where your house is.
That's where we
Okay.
live, yes.
Okay.
But then, so to the right of the house that does exist, that's our critical line.
Okay, so
the old critical line.
The house that exists faces the cul-de-sac, correct?
Yeah. Just
Okay.
our driveway. The
So-
driveway doesn't look exactly
I
like
gotcha.
that, but
Okay.
yeah.
And so where you want to put the pool is if you were facing the house from the cul-de-sac or driveway, whatever, it would be to the left going towards Bohicket Creek, correct? If you're facing it from the driveway.
Between the house and the critical line.
Yes, okay,
Yes.
all right.
Okay, and then that last one was, this is the current, the dotted line is the critical area. And see, like, towards the left side of the dock, that little, like, rectangle that juts out.
Is it just, I'm kind of following the critical line, is it just like one corner of the pool that really needs to?
The whole pool is not.
That's kind of what I'm getting at. So
infringing
it's-
on the
okay.
critical or the 50-foot setback.
And you really can't go any further because of the drainage ditch and all that. I see what you're saying. Okay. All right.
Anyone else have a question of Mr. Hancock? Thank you so very much for your time, sir, and your testimony tonight.
Thank you.
Do we have anyone else that'd like to speak in favor of this application? Anyone else? Do we have anyone to speak in opposition? Yes, sir. Please come forward. State your name and address for the record, sir.
Good evening. I'm Kevin Richburg. I live at 6850 Bears Bluff Road, Wadmalaw Island. I'm here tonight actually representing the Wadmalaw Island Land Planning Committee, and I believe we have submitted a letter of opposition, which I would assume you guys have. And I'm going to be very brief. I don't plan on going over our entire letter, but I just want to say kind of in a quick summary that because the applicant's request is not in compliance with the Wetlands, Waterways, and OCRM Critical Line Ordinance and does not meet all the required variance criteria to establish a legal hardship, we'd ask that you deny the variance. In the event the board does decide to approve the application, we would ask that the staff recommendation conditions be attached.
Oh, wow. Okay. I didn't get a chance to look up. Does anyone have a question? Thank you so very much, sir. You were very quick.
Like I said, we sent a letter in, which is a little more detailed, and I
Yes,
assume
sir.
you guys have that, so just kind of the summary of that.
Yes, sir. Yes, sir. No need to beat a dead horse, is it?
Yeah, and yeah, you guys have the letter. I see.
Yes,
Yeah.
yes. Does anyone else, would they like to be, anyone else to speak in opposition? Yes, ma'am. Please, if you would, state your name and address for the record.
Skinner, 1437 Fairview Plantation Road on Wadmalaw.
Thank you, Ms. Skinner.
And I also would like to concur with the letter that what they had provided me with a copy of it as well as a former member of the Land Planning Committee. And I agree with that it did not meet, actually, I agree with them that it didn't meet 5 of the criteria. And it's the Ordinance 9.7.2 calls out the soil disturbance structures and impervious surfaces. And I can see some wiggle room when you don't have an impervious surface, but you know, I've spoken before this body before how I feel about marsh migration. And so that's what I'm concerned about with it, that this is it does not prohibit the use of their property because the pool can be relocated, but it's not going to give them the privacy, and but the front between the ocean with the the creek between the critical line is important. That the salt marshes, and we have also within the county, well, let me skip, I'll come back to that one. But it does apply, I think it does apply to other, they said it doesn't apply, but everybody has to meet the same OCRM critical line buffer. And I think Ms. Working just stated that some of these pools that don't meet were prior to the comp plan being instructed. So the OCRM ordinance didn't exist at the time, so they would be legal non-conforming. I also do not feel it restricts the utilization of the property, as is in their letter. I'll be brief with it, because the pool can maybe be made smaller or relocated to another part of the property. And the fact that it's not due to their own actions, they bought the house, they're putting in a pool, so move the pool or change the size of it. And then as far as number 7 with the comp plan, this is when I wanted to bring back up that, the county has hired a resiliency director, and you have a resilience committee. There are several ordinances coming before the Zeldar soon to be reviewed by the Planning Commission and County Council to be passed. And there are tons of people. The town of Kiowa Island, because everyone's concerned about marsh mitigation, the town of Kiowa, working with their Kiowa Conservancy, they have spent thousands of dollars, and they're hiring consultants so that they can come up with the marsh management plan, because it's a fact that the sea level's rising. So within this, and Seabrook Island is now looking into all of this. So that's part of where I go with the resilience, not meeting the comp plan, with the resiliency efforts that are going on due to the rising sea level that we have due to climate change.
Okay.
And that was all.
Thank you, Ms. Skinner.
Okay.
Hold one moment.
No.
Does anyone have a question of Ms. Skinner? Mr. Borkin?
Yes.
Oh, I thought you.
No, just taking my
I thought I
glasses
saw your glasses at the corner of my eye. Anyone? Thank you, Ms.
All right,
Skinner.
thank you.
For your time. Do we have anyone else that'd like to speak in opposition? Mr. Hantuck, you have 2 minutes for rebuttal, sir. Please remember to state your name and address, sir.
Ben Pantuck, 1980 Long Creek Road, Wadmore Island. I would say, first of all, that we are totally okay with the conditions that were attached to this, and we'd be willing to go along with that for sure if you grant this exception. And we for sure understand the importance of the wetlands, and it would impact us poorly if we ruined it in front of our home. That would not be something we would want to do in the first place, but we're still leaving a 35-foot buffer, and that's only the very one corner of the pool even goes that far. Most of it is within the 50 feet. I would argue that there's not really another spot on our lot that would be sufficient for this pool. We've already reduced the size of it and changed the location to move it closer to the house and make it smaller to fit within that when we thought we had more based on the old survey. And I don't think this will have a negative impact on the critical area personally.
Okay.
That's it.
All right. Does anyone have a question of the applicant?
Question.
Yes, Mr. Williams.
What size pool are you looking to build? Square footage?
It was on the plans were in there, but I want to say it was like 34 or something. I don't know. I would have to look at the plans, which were in the packet.
34 by...
34.
Oh, sorry. Go ahead. 18.
Good question, Mr. Williams.
Yeah, there we go.
Anyone else?
18.
Thank you, sir, for your testimony again today and your rebuttal. All right. This case is closed to the public. Do we have any discussion? Okay, then can I get a motion to either approve or disapprove this application? Anyone on my left? Anyone on my right? Ms. Asbill? Asbell? Is it Bill or Bell? Bell. Thank you. I didn't mean to make you blush. I didn't mean to make you blush.
Okay, so for case BZA-01-22-00550, I'll make a motion to approve the variance based on the following conditions. One, that there are extraordinary and exceptional conditions pertaining to the particular piece of property. Criteria 2, that these conditions do not generally apply to other property in the vicinity. Criteria 3, that because of these conditions, the application of the ordinance to the particular piece of property would prohibit or unreasonably restrict the utilization of the property. Criteria 4, that the authorization of this variance will not be of substantial detriment to the adjacent property or to the public good. Criteria 5, that the BZA will not grant a variance, the effect of which would be to allow the establishment of a use not otherwise permitted in a zoning district. Criteria 6, that the need for the variance is not the result of the applicant's own actions. And criteria 7, that granting of the variance does not substantially conflict with the comprehensive plan or the purposes of the ordinance. And then I would also include staff's 3 conditions. 1, that prior to commencing construction, silt fencing will be installed along the critical line, and the silt fencing will be maintained for the duration of the construction. 2, that the applicant shall use stormwater mitigation measures such as the use of rain barrels or rain gardens to reduce the flow of stormwater into the marsh. And 3, that the encroachment areas shall be limited to the footprint areas shown on the submitted site plan.
Thank you so very much. Do we have a second?
Second.
All right, we have a second. Questions? Comments? I'll bring it to a vote. All those in favor, please indicate by saying aye and raising your right hand. Aye. Opposed? Oh, we got two that oppose. All right. So it still carries. Your application, sir, has passed. Within 10 business days, you will get information from staff letting you know the next, 10 working days, excuse me, let you know exactly what the next steps are in the process. Once again, congratulations. Good night, sir. Okay. The next case we have on the docket is case BZA-01-22-00551. And that will be done by Ms. Murray.
All right. The applicant and property owner, Bill Park, and Representative Aaron Eid of Architecture Plus SC are requesting a variance to reduce the required 15-foot interior side setback by 1.7 to 13.3 feet at the closest point for a portion of the proposed residence. Variance to reduce the required 50-foot front street side setback by 11.2 to 38.8 at the closest point for a portion of the proposed stairs and residence, and a variance request to reduce the required 50-foot OCRM critical line setback by 10.1 to 39.9 at the closest point for a portion of the proposed swimming pool, stairs, and residence at a property located at 1535 East Deep Overlook in the East Area, TMS 61714-00047. Here are some part of the ordinance requiring the setbacks. This is the subject property showing the surrounding properties in our Charleston County Rural Residential Zoning District. The subject property is 0.39 acres of highland and is currently vacant. This property is in Phase 2 of the Paradise Island subdivision and was platted in 2004. The Charleston County adopted the required setbacks and buffers from the OCRM critical line in 2001. Here's a zoomed in aerial of the property, zoomed out aerial. This is a photo of the front of the property. Here's some more shots of the subject property. This is East Deep Overlook. So staff finds that this request meets criteria 5, and it may meet 1, 2, 3, 4, 6, and 7. The Board of Zoning Appeals may approve with conditions, or deny case BZA 0122-00551 based on the BZA's finding of fact, unless additional information is deemed necessary to make an informed decision. In the event that the board decides to approve the application, the board should consider the following conditions recommended by staff. 1, prior to commencing construction, silt fencing shall be installed along the critical line. The silt fencing shall be maintained for the duration of construction. 2, the applicant shall use stormwater mitigation measures such as the use of rain barrels or rain gardens to reduce the flow of stormwater into the marsh. And 3, the encroachment area shall be limited to the footprint areas shown on the submitted site plan. Here are site plans submitted by the applicant. This is a little hard to see up here, but it is showing the buildable area of the parcels in the area near him and near setbacks. Here's the site plan of the home as proposed on the property. Plat. Oh, this is the plat. Any questions of staff?
Any questions? Thank you, Ms. Murray. Is the applicant present? Yes, sir. Please come forward and tell us why we should approve your application, sir. Please state your name and address for the record, sir.
Good evening, everyone. My name is Aaron Ead, 754 Kit Hall Road, McClellanville. I am from Architecture Plus. I'm the designer on this project. I'm here representing Bill and Jan Park. Thank you for taking the time to carefully review our project. We are seeking a variance on relief related to setbacks. We hope you are able to see our sincere good faith effort to adhere as closely as possible to the intent of the setback requirements, excuse me, while still providing a reasonable solution for the owners. We hope you agree with our approach and look forward to your support in finding a resolution for these issues. So the gist of the issue at hand is an odd site geometry resulting in a challenging buildable area. We've tried to limit encroachment into the setbacks in 4 ways: a modest building size, careful arrangement of building elements, limiting encroachment into the setbacks with lighter elements, such as stairs, decks, porches, and where possible, minimizing the principal building massing encroachment. Number 4, we've actually pulled portions of the decks and porches into the heated footprint to reduce the rear encroachment to the OCRM setback by a further 4 feet. If everybody could look at Exhibit A, I believe that's the first page of our submittal. Geometry of the site, as stated before, is resulting in a low buildable area relative to the size of the lot and by comparison to regularly shaped neighboring lots. The allowable 30% buildable area should allow for us to have 5,095 square feet of buildable area. Our geometry with the 50-foot setbacks is limiting us to 18.9% buildable area, or 3,160 square feet, with quite an awkward shape. Hypothetically, were we to reduce the rear 50-foot setback by 15 feet to 35 feet, we could increase the buildable area to 27.7%, or 4,626 square feet, still below the allowable 30%. We're not seeking even that. We're seeking only our footprint, 26%, which is less than that of all immediate neighbors, and an encroachment of no more than 11.2 feet at the greatest point. If you guys could look at Exhibit B, which I believe is page 2. As you can see, a visually low impact front stair is encroaching into the front setback by, at our furthest point of 11.2 feet. Encroaching building elements to the rear are the pool, deck, and porches. There's a small corner of the laundry pantry area that encroaches at an atypical side setback situation with the neighboring lot to the north. If you could please refer back to Exhibit A for a moment. Note the irregular shape and location of the neighbor's buildable area relative to that encroachment. As far as the side setback situation, I don't think that's going to encroach into his side setback in a way that's meaningful given the odd shape of his site. If we could look at A 1.1. So limited portions of the main massing encroach into the setback at the first floor living area. A corner of the living room, the small corner at the laundry pantry previously mentioned, and a 6-foot portion of the second floor family room above the riverside covered dining that we will see shortly. We have attempted to further limit the amount of encroachment into the rear setback by the visually low impact pool, deck, porch, and by sacrificing, as before mentioned, heated living space at the kitchen and living room. Here we have pushed the exterior doors into the main massing of the home. This is reduced the encroachment of these elements by 4 feet while allowing for a reasonable size deck and reasonable size porch areas. So if you guys could look at A1.2 real quick. So A1.2 shows that second floor family area, and that's encroaching into that rear setback by 6 feet. If we can move to A2.4, those are the model images up on the screens. In the top left image, in this image, you can see the lightweight stair encroaching into the front setback, as well as the small portion of the main massing at the corner of the first floor living room. In the bottom right, in this image, you can see how we've limited encroachment into the setbacks by mostly limiting it to low impact elements such as pool, decks, porches, and by pushing the exterior doors back into the main volume. The limited 6-foot encroachment of the family room and the second floor massing can also be seen here. So along with the encroachment of the footprint elements, we're seeking...
Excuse me, sir. Your
Sorry.
time has elapsed.
Okay. I'm wrapping it up with one more sentence.
30 seconds, sir.
Okay. Along with the encroachment of footprint elements, we seek approval for tertiary elements extending into the setbacks such as trim details and deck edge overhangs. We look forward to your comments.
Okay. Thank you, sir. One moment, sir. If you hold tight.
Okay.
Does anyone have a question of their architectural record? Well, you did good. Thank you. Thank you. You may be seated, sir. Thank you. Do we have anyone else that would like to speak in favor of this application? Mr. or Mrs. Park? Please state your name for the application, sir, for the record.
Yep, Bill Park, 1895 Pierce Street, Daniel Island, South Carolina. When we originally did a feasibility study to look at the land, we had the house oriented basically along the line of that odd-shaped buildable area. If you remember on one of the drawings to the north of us or to the east of us, there's a long peninsula that juts out with another large home that's going to be on it. So we had to shift our sight lines a little bit instead of our sight lines going right at that large house. And doing that made our masses shift quite a bit. So like Aaron said, we tried to keep everything as tight as possible.
What made you decide on this lot?
Water, we have three girls, hopefully grandkids, and bring them all back and enjoy the water.
Good. Does anyone have a question of the applicant? Thank you, sir, for your testimony today. Do we have anyone else to speak in favor of this application? Do we have anyone to speak in opposition? Case is closed to the public. Any discussion? Questions? Yes, sir.
I have a question for staff, I think. Help remind me, Paradise Island, this was platted forever ago and OCRM setbacks have changed. Is that essentially what's happened, buildable areas and all those kind of things? Is that right?
Yeah, well, this particular phase was platted after 2001.
Okay.
But we did reach out to the developer, I think it was after your December meeting, but he said that there's only one lot still under the developer. All the other lots have been sold by individuals, so.
Gotcha.
But they're brainstorming, because we are having some issues like with the driveways encroaching and things like that.
Thank you, sir. Anyone else? All right, we're moving right along, folks. At this time, I would like to entertain a motion either to approve or deny case BZA-01-22-00551.
All right, Mr. Chair, in the matter of BZA 01-22-00551, I will make a motion that we approve this request. I do find that, one, as we have in other circumstances similar to this, there are extraordinary and exceptional conditions pertaining to this particular piece of property. Two, these conditions generally do not apply to other properties in the vicinity. Three, because of these conditions, the application of this ordinance to this particular piece of property would effectively prohibit or unreasonably restrict utilization of the property. 4, the authorization of this variance will not be of substantial detriment to the adjacent property or to the public good, and the character of the zoning district will not be harmed by the granting of the variance. 5, the Board of Zoning Appeals shall not grant a variance, the effect of which would be to allow establishment of a use that is not otherwise permitted. We certainly meet this criterion. 6, the need for the variance is not the result of the applicant's own action. Again, we are clearly witnessing the rise of, or the change of critical line that has a direct impact on lots that were planted or platted 20 years ago. And 7, granting of the variance does not substantially conflict with the comprehensive plan or the purposes of the ordinance. In making this motion, I would also state that we should add the 3 special conditions recommended by staff. That 1, prior to commencing construction, silt fencing shall be installed along the critical line. The silt fencing shall be maintained for the duration of construction. 2, the applicant shall use stormwater mitigation measures, such as the use of rain barrels or rain gardens to reduce the flow of stormwater into the marsh. And 3, the encroachment areas shall be limited to the footprint areas shown on this submitted site plan.
Thank you, Mr. Nelson. Do we have a second?
Second.
All right, Mr. Boykin. Questions? Let's bring it to a vote. All those in favor, please indicate by saying aye and raising your right hand.
Aye.
Aye. Any opposed? It is unanimous. Thank you so very much. Your application is approved. Within 10 working days, you'll be getting information from staff, letting you know the next steps in the process. Once again, congratulations and have a good night.
Thank you.
Okay. Getting down to the last few here. Our next case tonight is case BZA 01-22-00552. Will be done by Mr. Joshua Downey. If you hear something grumbling, that's my stomach.
I'll read really slow. All right, so BZA case 01-22-00522. The applicant, Charles Heidel, on behalf of the property owner Candace Thompson, is requesting a special exception to establish a short-term rental, extended home rental in the low-density housing manufactured subdivision at 1630 Turns Nest Road, TMS number 331-07-00069 on James Island in Charleston County. The subject property and all the surrounding properties are located within the low-density housing manufactured subdivision zoning district. The property contains a manufactured home with 3 bedrooms that was placed on the property in 1995 per Charleston County records. The request is to rent out all 3 bedrooms for up to 144 days. Staff did conduct a site visit on February the 17th. That is a picture of the subject property. A zoomed in aerial view, a zoomed out aerial view, picture of the subject property, the dwelling, and as well as the sign that was placed on the property on the 17th. That is a manufactured home as well as the parking areas. Here are some of the surrounding properties in the area. And that is Turns Nest Road. Staff does believe that all 3 of the criteria have been met. The Board of Zoning Appeals may approve with conditions, or deny BZA case 01-22-00552, the special exception to establish a short-term rental, extended home rental in the low-density housing manufactured subdivision, MHS zoning district at 1630 Turns Nest Road, TMS number 331-07-00069 on James Island in Charleston County, based on the BZA's fact finding, unless additional information is deemed necessary to make an informed decision. The board may modify any of the staff's recommendations, conditions below, including but not limited to the restriction of the number of days the short-term rental may be rented. In the event that the board decides to approve the application, the board should consider the following recommendations by staff. Prior to the zoning permit's approval, the applicant shall complete the short-term rental limited site plan review process. The use shall comply with all of the requirements of Article 6.8. The property shall not be used for more than 144 days in aggregate during any calendar year, and the property owner shall be responsible for ensuring that the tenants comply with the Charleston County noise ordinance. That is the site plan and the plat. Any questions?
Good job, sir.
Thank you much.
Applicant available? Yes, sir. If you would, please come forward, state your name and address for the record, and please tell us why we should approve your application, sir.
Charles Idle, 1567 Turns Nest, Charleston. I'll be quick.
Take your time.
My wife and I live just up the road. We know and love the neighborhood and the neighbors. We get along with all of them. We've been very open with them about the idea, and everyone's been supportive. We tend to stay there for a long time, so we're going to try to do this as harmoniously as possible. Besides that, we're going to prohibit any outside guests, any parties. The adjacent neighbors, I've spoke with each of them, Bill and Mac, and they have my number, so they'll alert me if any problems. And I walk my dog past it about 3 times a day. So they will be watched. And that's about it.
Okay. All right, hold on one moment. Does anyone have a question of the applicant? You must have impressed us.
I'm hungry.
Thank you. Do we have anyone to speak in favor of this application? Anyone else? Do we have anyone to speak in opposition of this application? This case is closed to the public. Questions? Well, I'm going to look to my right and then look to my left and see if anyone has a motion that they would like to make either in opposition or to approve or deny this application. Yes, sir. Mr. Marchant.
In the case of BZA-01-22-00552, I move to approve the application, as I believe it meets all 3 criteria. Criteria 1, it is compatible with existing uses in the vicinity and will not adversely affect the general welfare or character of the immediate community. As the applicant states, he lives just down the street. He's gotten approval from his neighbors. He will watch this property every day to make sure that it does not as adversely affect the general welfare. It meets criteria 2. He's made adequate provisions have been made and or exist for such items as setbacks, buffering, including fences and or landscaping to protect adjacent properties from the possible adverse influence of the proposed STRP use, such as noise, traffic congestion, trash, parking, and similar factors. As the plan and the applicant stated, there's adequate room. His rental agreement will prohibit outside guests, and he's got neighbors on the watch as well with phone numbers intact. And it meets criteria 3, complies with all applicable rules, regulations, laws, and standards of this ordinance, including but not limited to any use conditions, zoning district standards, and applicable STRP site plan review requirements of this ordinance. In addition to meeting the 3 criteria, this motion includes 4 conditions. Prior to zoning permit approval, the applicant shall complete the STRP limited site plan review process. Condition number 2, the use shall comply with all requirements of Article 6.8. Condition number 3, this property shall not be used as a short-term rental for more than 144 days in aggregate during any calendar year. And condition number 4, the property owner shall be responsible for ensuring that tenants comply with the Charleston County noise ordinance. Herein ends my motion.
Thank you. Is there a second? Mr. Nelson, thank you. Questions? Discussion? Let's bring it to a vote. All those in favor, please indicate by saying aye and raising your right hand.
Aye.
Aye. Any opposed? Unanimous? Congratulations, sir. Your application has been approved. Within 10 working days, you'll be getting information from staff letting you know the next step in the process. Once again, congratulations and have a good night, sir. Look, high five there. All right, last case for us tonight will be presented by Ms. Murray. It's case BZA-01-22-00553. Ms. Murray.
All right. The applicant and property owners, Irma and Ruben Covarubio, are seeking a variance to reduce the required 50-foot front street side setback by 13.6 to 36.4 for an existing horse stable. The property is located at 3758 Humbert Road on Johns Island. The TMS is 250-00-00219, and the property is located in the agricultural residential zoning district. Here is the page from the ordinance stating the required front street side setback. Here is the subject property, which is 4.31 acres. The subject property contains 3 existing accessory structures, including a storage container, a 1-story cottage, and a horse stable. Between 2019 and 2021, the structures can be seen on aerial imagery. However, no permits were obtained when the structures were erected. The 1-story cottage and storage container have since been brought into compliance and permitted for personal use in 2022. And as you can see on the zoning map above, the properties to the north of the subject property are located in a planned development, and those around are mostly in AGR, except a few in AG8. Here is the zoomed in aerial, and here's the zoomed out. Here is the zoning sign in the front of the subject property. Here is the subject property showing the existing horse stable. Some more shots of the subject property. And this is Humbert Road. So on the site plan, which we'll look at in just a second, the horse stable is actually labeled as a shed. And so these are the current conditions of the property. So you can see the horse stable up in the corner of the property. The cottage is where with the red roof. And then all the way in the back, on the same side as the cottage, is where the storage container is located. So this is a 2019 aerial image of the property, where you are only able to see the storage container, which is up in the right corner where the horse stable is now. Is that the right? Yeah. Okay. This is a 2015 aerial. So staff found that this request meets criteria 2, 3, 5, and 7. It may meet criteria 1 and 4, and it may not meet criteria 6. The aerial imagery is shown because the applicant purchased the property according to the deed in 2014, and the structures aren't shown on aerial imagery until 2019, when you start seeing the first ones. So, point of clarification. The Board of Zoning Appeals may approve with conditions, or deny case BZA 01-22-00553, the variance request to reduce the required 50-foot front street side setback by 13.6 to 36.4 for an existing horse stable at 3758 Humbert Road on Johns Island in Charleston County, based on the BZA's findings of fact, unless additional information is deemed necessary to make an informed decision. And we had no conditions. Here's the site plan, where you see the cottage and the shed. There's a proposed home, but that is not on the property. And here's the plat. Any questions of staff?
Yes, sir.
Sorry, can you help me with the timeline? I'm a little confused, so sort of go through that again.
Yes. So based on the application, the applicant stated that the structures were already on the property at the time of purchase. So I feel that would be a point of clarification because the deed that we have says that they purchased it in 2014. But you don't see the buildings on the aerials until between 2019 and 2021.
Thank you. Any other questions? Good question for the applicant. Thank you, Ms. Murray. You're the only ones left in here, so you got to be our applicants. Please come forward, tell us your name and address, and tell us why we should approve your application.
Okay, my name is Irma Cuba Rubio. Address is 3758 Humber Road, Johns Island. And I'm here to see if you guys could approve the variance because there was a building there before. Some of the people that I purchased the property from had goats and animals there. And they had like a small little shed. So we actually remodeled it. I sold my house in 2020, so I needed to move my horses. So we, just remodeled it. And I didn't know, I mean, it was there, the building was already there, so I really didn't know the setbacks, thinking that it was fine where it was already. So we just followed what it was there already. So I'm just here to see if you guys could approve this. And I also know my neighbor next door. She has approximately like 22 acres. So I talked to her and, because the building sits in front of her house, but it's like ways. So she, she has no problem it being there because it was already there. So, I'm gonna be brief tonight.
No, we
gotta
need to
go to
take our
bed.
time. We got to get down to
Yeah.
the bare facts of it. Is that all?
That's it.
Okay, well, thank you. I just have a question, point of clarity. Actually, when did you purchase the property?
Like she said, 2014.
2014?
Yes.
So, okay. All right. And you're going to use this for horses?
We have horses, we have some stables and horses, and I'm gonna build a home eventually on it.
What kind of horses and how many?
3.
Okay.
Three
And what kind?
horses. We have an Arabian, Andalusian Spanish horse, 2 Arabians and an Andalusian Spanish horse.
Okay. Can you, go ahead, Mr. Boykin, I saw you.
I was going to tease you and say no Pasafinos.
Pasofinos, yeah, my husband likes the Pasofinos.
I was trying to, I'm trying to, and I'm going to follow up on what Ms. Murray's got going up right here. So we're looking at a 2015 aerial image of your property, and I'm looking over in that corner. I see some shade. I can't tell if there's anything there from my viewpoint. Is there a way to zoom in on that at all in that corner where the building is now?
Let me try.
Sorry, I didn't mean to.
Very okay.
Looks like a pond.
I don't see anything.
Yeah, so Ms. Rubio,
Yeah.
sorry.
Cuba
My mouth.
Rubio.
Cuba.
Yeah, you say Cuba and break it up, and then
Thank you.
Rubio.
All right, sorry, my Spanish fails me. Anyway, I guess what I'm trying to say is, looking at that image, taken, I guess that was 2015, there doesn't appear to be any evidence of a building being there. And y'all bought the property in 2014. Do you have any explanation why the photograph doesn't show the building that you claim was there
I
prior
have
to
no
buying?
idea, but it was in the corner. It was like a little shed. I should have brought pictures. Huh? Yeah, it was a small one for one horse.
Okay.
But it was like in the corner. I don't know why it wouldn't show it on there.
Did
Yeah.
you get, go ahead.
I'm just looking to see, I can't say with any certainty what is or isn't there because it's very dark in that corner. Well, obviously there's some trees there. There's some shade cast from those trees. I agree with everyone else up here. I cannot see a building, but I cannot say that there might not be something under the tree from the angle of the photo in that corner. I see a large tree standing right there on the property line. But what would you estimate? Having horses, I mean, you don't need a lot of space if it's just a singular stall for them to be tied up in. I
Yes,
mean,
that's-
what was it, 10 by 12 or something like that? I mean, how large was it?
Yeah, I would say 10 by, what do you think, 15? ¿Cómo estaba de grande? Like 8 by 10, it was pretty small. It was
And
pretty
I'm
small.
not trying to be, I could see that an 8 by 10 building could be hidden by that tree. Again, I have no way to
Yeah.
confirm or refute your claims, but I do agree we can't see it in that photo. But you're under oath.
Yeah.
And your testimony is that there was a building there. And y'all obviously either replaced it or modified it
Yeah.
I really don't have any other questions unless anybody else has got any.
Yeah, I did have pictures of it. I should have brought them with me. or should
That
have
would have been
submitted
very
it.
helpful, yes,
Yeah.
ma'am. If you'd had some
But, yeah.
photographs of what it looked like prior to what's there now, that would have been very helpful. Sorry, that's all.
Thank you. Any more questions of the applicant? Okay. Thank you so very much for your testimony today.
Thank you for having me.
Yes. Sir, do you have anything you'd like to say?
Do the honors.
All right, since there's nobody else in the room, I take it that there is no opposition. Case is closed to the public. Questions? Concerns? Mr. Marchant?
My only concern is the evidence does not line up with the testimony, and I would ask that the applicant come back with more evidence so that we can adequately approve a request that meets criteria number 6, because right now, in good conscience, I have a hard time approving something that seems false.
Well, I would follow that up with a motion at the appropriate time for a deferral, if that be the pleasure of the board.
I would support that.
That they
Mr.
have
Nelson?
provided testimony under oath that is there, and they could be held in contempt if that's not the case, if it's found to not be true.
Fair comment.
I think she said it was 8 by 10.
Right.
So that could be another issue. I mean, it's obvious that they now have a 40 by 26 building.
You can fit a
So
horse
it
in an
could
8 by
be-
10 enclosure.
Well, so it could be that we just can't see it because it's that small. 8 by
Right.
10 is pretty small.
I mean, you look at a horse trailer and we
And-
stack
yeah.
them in there and I mean, you can, they don't need a lot of room, but and again, for a single horse, it could be small. And I'm not saying there was or wasn't. I guess that tree is in an, unfortunate spot that it'd be sad if we were wrong in judging this and there was a small building we couldn't see. If
I mean,
she has
yeah.
photographs, that would be very
They
helpful.
wouldn't need permits for an 8 by 10 structure. So, I mean, regardless, it wouldn't really, I don't know. I think it's kind of like a moot point, really.
I see your point,
Because
yes.
the point is they need permits for what they built.
Right.
So,
Well, what say you, Mr. Marchand, on that point?
I guess the question is, if you built something that wasn't compliant, so she's asking for, I should be talking, she's asking for forgiveness. All that had to be said was, I'm asking for forgiveness.
That would be the case, yes, sir.
Well, anything that they have has to be built up to code now, because the spotlight's on them. Okay? Any more questions, comments?
No, sir.
All right. I need a motion to either approve or disapprove.
I'll take,
Go ahead.
go ahead. I've already handled one. Go ahead.
Go ahead, Mr.
Well,
Mr. Williams?
I was going to motion to approve the application.
Go ahead, then.
Do it.
There are extraordinary and exceptional conditions pertaining to the particular piece of property. I believe that there is, because there was already an existing, according to the applicant, existing structure there where they want to build on. Criteria number 2, the conditions do not generally apply to other property in the vicinity. These conditions do not generally apply to the other properties in the vicinity because of the location of the existing pond. I believe that it does meet that condition. Condition number 3, because of these conditions, the application of this ordinance to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. They are applying based on a building that was already there in place. Criteria number 4, the authorization of a variance would not be of substantial detriment to the adjacent property or to the public good and to the character of the zoning district would not be harmed by the granting of the variance. They spoke to the neighbors, and the neighbors have no problem with their building. Criteria number 5, the Board of Zoning Appeals should not grant a variance to the effect of which would be to allow the establishment of a use not otherwise permitted in the zoning district to extend physically a non-conforming use of land or to change the zoning district boundaries shown on the official zoning map. The fact that the property may be utilized more profitably should a variance be granted may not be considered grounds for a variance. It does not change the zoning district. Criteria number 6, the need for the variance is not the result of the applicant's own actions, as they gave testimony that they that there was already a building there, and they're looking to they wanted to work on the building that was already there, as they shared in their testimony. Criteria number 7, granting the variance does not substantially conflict with the comprehensive plan or the purpose of the ordinance. It does not conflict with the plan, the comprehensive plan. That's my motion. Thank you.
Thank you, Mr. Williams. Do we have a second? Second. All right, Mr. Nelson. We have a motion that has been properly moved in second. Any questions or discussion? Good. Let's bring it to a vote. All those in favor, please indicate by saying aye and raising your right hand. Aye. All right, it looks, any opposed? It is unanimous. No, I oppose. Oh, you oppose, I'm sorry, I apologize. It still carries. Congratulations, your application was approved. Within 10 working days, you'll get information from staff letting you know the next steps in the process. Once again, congratulations and good night.
Yeah, I was going to say, if you can please email me the photographs tomorrow morning.
Well,
Oh,
there we
okay.
go.
I never doubted it was there.
Right.
Photographs, if they aren't clear, if they don't really
These two.
zoom in.
Yes.
Yeah, sure. That was right there. That's right there.
Oh, yeah.
I'm good.
So for April, we're going to have 9 new business cases. It's getting a little crazy. May feel like it might be about that, if not 10, so. And now people, I think, that come to these meetings maybe realize why we cut it off. I know it's hard because no one wants to be cut off the agenda, but it is what it is. It's happening. I'm having to cut people off the agenda.
Your cases are what?
I'm sorry?
The majority of the cases, what are they?
Variances primarily, yeah.
Okay, no short-term, well, mostly
No,
short.
not many.
Not many.
Like 1, maybe out of 9.
Wow.
Yeah. Maybe 2, yeah.
Well, anything else that's good for the board? Ms.
And
Work?
then just the reminder about training of your food for the annual meeting is lined up with your name. You do have to sign your name because for procurement purposes, that you received this food for training, so. And I'd be happy to do a training. I think it's probably, honestly, with the amount of cases we have, it's too much for any of us to handle doing a training on the same day, but if we could do maybe like a Zoom training, like on another Monday. I just think trying to plan things when we know we're gonna have 9, 10 cases a month, it's a little difficult.
Well, I'd also like to see if we can move that meeting up possibly an hour.
Okay.
Just so we, with 10 cases, we'll be here to 10 o'clock. And I'm not a proponent for that. Is it possible we can move the meeting up
an
If we have
hour?
enough people that can come.
Well, that's why I'm asking that question. Would anybody be opposed?
I'm available. I can't speak for everyone else.
Which day is that?
Yeah, I
Yeah, this next meeting. You can do 4. Mr. Williams, can you do 4?
You are,
Still come in at 5?
Yeah, still coming at 5.
Mr. Marchant?
Most of y'all can then.
I have a conflict, so no, I can't.
April.
So you have a conflict, that you won't be at the meeting at all, or?
Well, I might be late to the regularly scheduled meeting. I'm hoping to be on time to the regularly scheduled meeting. So it's,
Mr. Freeman?
I would be able to make it.
You would be able to? Good for you. Let's move forward then.
As long as we've got a quorum when we start at 4 and
That's-
start hearing cases, the others can join in when they arrive at 5. Would that be acceptable?
just one other, well, 2 comments. One, I think hold these people to 2 minutes. I mean, it's 2 minutes. Just cut them off and don't feel bad about it, and that's okay.
Well,
And-
if we keep asking questions, that just
Well, I know.
strings them out there.
And that's our fault. And then the other, and Mr. Hughie, forgive me, we've got to change the process. I mean, if it's in written word and I can say I approve based on everything written here, I think that should be adequate enough, and that would save 10 minutes per case. Just a comment.
Oh, that's not my requirement. That's the county, because when things are.
I know, so maybe the county.
county attorney.
Talk to the legal department.
I mean, I think procedural efficiency would be helpful.
Yeah, sure.
Especially on the ones where we're not adding anything. It's as written and as requested by staff. I move to approve. Second, done. Right? I mean, I would love to see that happen. So.
Calvin, do you want to talk to the county attorney? Because it is the county attorney.
I mean, I'm on city's Board of Zoning Appeals, Site and Design, and that's what they do.
Yeah.
As a matter of fact, when there's no opposition, their position is it gets approved.
Yeah, if you can talk to the county attorney, that would be good, because that's where this is coming from.
I'm happy to. I'm also going to sign your name when I get my sandwich.
Can I ask a quick question? And Mr. Eugene, maybe you know the answer to this. The Santee Cooper appeal to the circuit court, do we know where that stands, or can you discuss that?
So, because there's no
Good night.
conflict, the county attorney's office handling it. So I'm just kind of, but I'll get an update.
I mean, I know it's in status, but I was just curious kind of where they were with it.
Yeah, no,
That's it.
I'll get an update for you.
Anything else for the good of the body, this august body? Ms. Workin, anything else? Ladies, we appreciate your help, your knowledge. Means adjourned.
John's feeling left out.
You feeling left out, man?
that me?